Okay, good morning. I hope you can hear me clearly. For those of you that are joining us online, good morning, good morning, good morning from the Ministry of ICT Hub in Nakawa. My name is Kenneth Mohanji, and I am very, very, very happy to be here this morning. I feel like a TV presenter, but this is how the symposium is like. I look like I have a panel here, which I'm going to ask questions on, like a Good Morning Uganda show. But for the advocates that are joining online, it's a pleasure to host you this morning for day one of our KTA annual symposium, hosted together with Uganda Law Society and with our partners, Konrad Adenauer Stiftung, British Council, the Ministry of ICT, of course, that is giving us a space, ITC, SBC, and others that we shall be introducing later on during the day. My job is simple. It's just to remind you that this is the 8th edition of our 8th annual symposium, and that our mandate really is to make sure that we encourage advocates to branch out of the areas of law that they may be used to and to see what else is out there. We know that this year being 2025, the biggest issues that we have as a country, as a society, are the shrinking cake for advocates and the need for us to be able to expand our repertoire, to expand our areas of specialty in the hope that we can be able to also have our bank balances expand, and beyond that as well, that we can also be able to expand our expertise. And so today we shall be having very eloquent presenters telling us about blockchain, telling us about artificial intelligence, telling us about the creative economy, telling us about digital trade. And all of these, we hope, will be able to encourage you, fellow advocates, to see how you can be able to advise your clients, how you can be able to practice these areas of law in a way that speaks to who we are as advocates, very resilient in our practice. And so I hope that this day one will be one that you will enjoy. Day two, we will introduce officially. And to my right is the moderator, Catherine Akankwasa, who I will hand over to after I've done my job of introducing who our first speaker is. And to my left is also our first speaker after we have had the introduction from Uganda Law Society. So thank you very much for your time. We will be here the whole day. So I hope you have your tea, your water, your juice, your kombucha, all of those things ready. And so my job is to introduce the Vice President of Uganda Law Society, Mr. Anthony Asimwe, who I hope is online, and will be giving us our opening remarks. Over to you, Mr. Anthony Asimwe, VP of Uganda Law Society. Thank you.
Thank you very much, Kenneth. I see the vibe in the room, and I wish I were there. It seems to be very interesting and exciting there. Unfortunately, I have a court hearing, and that's the reason I can't be there with you physically. Nonetheless, I'm really with you in spirit. Our esteemed speakers, the organizers of this event, KTA team and ULS, the members of the bar, ladies and gentlemen, I bring you warm greetings from the Radical New Bar Governing Council and the leadership of the ULS. Particularly, I take this opportunity to officially welcome you to the 8th Annual Technology Symposium convened by KTA in partnership with the Uganda Law Society under this timely theme, digital trade, AI, and the creative economy as drivers for digital transformation. As you may be aware, one of our focus areas as the Radical New Bar is digital transformation, one of the core areas we started to focus on. This is an intentional move to really move with the trends because the world is moving. And I honestly thank the team, Kenneth and your team, for looking ahead and looking forward, and also contributing to this core principle, the core, one of our Ds, the 4 Ds, digital transformation. As you saw in our recently concluded Digital Transformation Week, the Tech Festival, these were mostly the focus areas, how members of the bar can, use technology can embrace the changes, what in the area of practice and all the aspects you're talking about. Members, over the course of this CLE training, we shall look into, as Kenneth has been saying, the evolving role of artificial intelligence, particularly its implications in impact, on the creative industries. We shall also examine the challenges and opportunities that lie ahead as we harness digital trend from what I've heard. AI and the creative economy to propel Uganda's digital future, because that's where we're headed. I once again wish to express my sincere gratitude. I hope I can still be heard. Sorry. I wish to extend my sincere gratitude to our distinguished speakers. I saw a whole line of speakers, experienced, the young members of the bar who have put in time and effort in, appreciating this digital transformation, AI and technology. I do really wish to appreciate them for graciously accepting this invitation and for your willingness to share your knowledge and insights, which is really voluntary. I know not everyone would spare time to share what they've achieved over time the way you have, especially the knowledge. I also extend once again my heartfelt appreciation to the KTA team, the Uganda Society, for their unwavering commitment in making this event possible. This is the 8th of its kind, and it's a demonstration of intent of moving into the right direction of where the nation and the world is headed, especially to benefit the members of the bar. A special thank you to all our sponsors who have also supported in ensuring that this event is possible. To all the participants of this event, this CLE, I encourage you to engage actively, have open minds, and take notes, ask questions, and reflect deeply as we collectively strategize for a future where the legal profession is not only responsive to digital transformation, but leads it. We want to have, want to be actively involved, we want to be at the forefront of this digital transformation era so that it benefits us and the general public. I thank you all for being here, and I wish you the best of the 2 days. Over to you, Ken.
Okay. Good morning once again. Thank you so much for the remarks that we received. Thank you so much. This is just to introduce one more time that the theme for this year's symposium is digital trade, AI, and the creative economy as drivers for digital transformation. So the segment focus is generally on understanding the creative economy in the digital age as it is right now, as we've seen how things are evolving and how we are having a creative economy that talks with what we're really talking about is ideas. We're talking about culture, we're talking about innovation, and how all of these help us generate economic value and economic value. So when we talk about the creative economy, we're talking about things like music, we're talking about film, we're talking about innovation and art and things of the sort. And what we're looking at is how do these areas help us generate value, economic value, yeah? And so what's exciting, though could be a little bit complex, is generally in how technology, especially artificial intelligence, is reshaping the creative works, how these are being produced, how they're being distributed, and equally how they're all being valued. And so we're seeing in this process of having a creative economy and having the use of AI and generally a more developed setting, we have questions like having new business models emerging. We're having new tools to enable creativity. And we also have so many questions based on the use of AI, questions of ownership, authorship, and generally having questions on who has a right to what, considering that, you know, we're using a lot of AI in most of what we're doing, and it's also helping us push businesses. And in the legal field, it's also helping us do a lot of our work. So to help us unpack this, we're going to have our first speaker, a lady called Olga Karunji. I will introduce her in a minute. Yes, I'll introduce her in a minute. What she's going to do is that she's going to delve into copyright, AI, and the new frontiers of ownership. She'll explore key questions such as who owns creative works generated or enhanced by AI. How do issues of authorship, privacy, consent play out in AI-assisted creativity? And also lessons that we can draw from Uganda's evolving digital creative economy strategies and from other jurisdictions. So this is me now introducing Olga. Olga is a senior associate at Chirunda and Company Advocates. She leads the firm's law science and technology team. Amazing. She also serves as the vice chairperson of the steering committee of the National Research and Innovation Program under the auspice of Science, Technology and Innovation Secretariat. She's a tech policy fellow with the Center of Law and Emerging Technologies at Makerere University. Olga is an advocate of the courts of judicature in Uganda and a member of the Chartered Institute of Arbitrators. She holds an honors law degree from Makerere University and a first-class postgraduate diploma in legal practice from LDC. Amazing. So now we're going to start. Olga, take us away. We shall have questions. I think the questions will come right after her presentation. We'll have a few questions from myself. Yeah, we shall have questions from myself, and we'll also have questions from the audience, but those will come right after her presentation. So, Olga.
Good morning, ladies and gentlemen in the room with us and online. Thank you very much for that very gracious introduction, Ms. Catherine. I am very privileged to speak to you this morning about copyright, AI, ownership, and the new frontiers of authorship. As we get into this discussion, I'd like us to step back a few centuries ago when Johannes Gutenberg invented the printing press. It changed the way books and texts were printed. It changed the distribution of knowledge. It democratized knowledge, in essence. On the flip side, it ensured that mass unauthorized reproduction of texts grew exponentially, and authors at the time were very agitated because their works were being reproduced without their consent. So what arose were questions of ownership and authorship that we're seeing now. At the time, one of the responses was enacting the first copyright law, the Statute of Anne in 1710. And those questions around authorship and ownership have arisen in the recent times, except that they're now at a grander scale because AI is growing so fast. It has proliferated. So we use it everywhere. It has impacted every single industry. If we look at papers like AI 2027 and the prediction it has on what AI is likely to do in the next coming years, the scale and impact it's going to have is even going to be greater than the printing press. But those questions around authorship and ownership are coming up again. We had prepared a presentation, so I'd like us to go over some of these questions that are arising and how we're interpreting authorship and ownership and what it means in the age of AI. So I think a great starting point would be the foundation of copyright. What does copyright aim to do at its heart? And you cannot talk about copyright without talking about human ingenuity, because copyright aims to reward human creativity. It does this by granting authors two very distinct rights. It grants them authors the moral rights, which is to be identified as an owner of a work, and that entails the right to paternity and also the right to integrity. That means that your work need not be, for the author not to be identified with works that are not consistent with their own works. But the other very important right that comes in is the economic rights. And this allows authors or any other owners of copyright to exploit the copyright commercially, because at the end of the day, copyright is a property right. Article 26 of the Constitution of Uganda guarantees the right to property. So once you own a copyright, you can assign it, you can transfer it, you can sell it, you can deal with it as you would any other property right. And so that is the foundational basis of copyright. But because AI has risen, especially generative AI that allows new content and production of new content by learning patterns from existing data, it's directly influencing the creative world. So literally dramatic, musical, artistic works are directly influenced by AI now. We have creatives using AI in their creative process, and the creative process is a complex thing. But just for understanding this conversation, there's a decision of the European Union Court of Justice it's called the Pena decision. The names are lengthy. But what the European Court of Justice aimed to do then was to break down the creative process into 3 steps: preparation, execution, and finalization. And in all these steps, we are currently seeing creatives using AI in all the steps, from preparation to execution and to finalization. But how does that impact the final product in terms of who will be deemed as the author for the purpose of moral rights and who will be the owner for enforcement of economic rights in the copyright? So determining authorship and ownership of AI-assisted works, the starting point is the author, because copyright does not protect ideas. It protects the expression of the idea, the fixation, putting down the idea into some form of format that you can see and touch and feel. And so the first approach is the natural person approach, and this is the most common and most consistent. We see it in Section 2 of our Copyright and Neighboring Rights Act. And it's the most globally adopted approach, that an author is the natural person who created the works. But you can't talk about an author without talking about the question of originality. And what does originality entail? We've seen various decisions talking about, under the Copyright and Neighboring Rights Act, for example, originality. To determine originality, you have to consider the independent efforts of the author, or the intellectual creation, the intellectual effort, the independent intellectual creation, the personal touch. There must be free and creative choices that are involved in the creation process. So again, the Berne Convention, the Copyright and Neighboring Rights Act, we have decisions like InfoPac that talk about and stress that originality has to arise from independent creative effort. What has happened now is that because of AI, the question of independent effort is just up in the air, because you can't say that you go to an AI tool like Midjourney or Delhi, for example, give a prompt, get an output, and still claim to have independently produced that work. So what happens in determining copyright now is there's evolving legal approaches to it. The first is that you must draw a separable distinction between the AI-generated enhancements and the original human authorship. One of the examples I can give here is the United States Copyright Office decision in the Cyborg application. In Cyborg, a gentleman made a drawing and then uploaded it to an AI that made enhancements to that drawing. But what the Copyright Office did in that case was to say that the human authorship portions of the output remained identifiable and distinct from the AI enhancements. It was clear that there was human authorship in that case. And so it became possible that it became a requirement that you must ensure that the AI enhancements are not so integrated that human authorship can no longer be identified. And that's such a complex thing to do, because it means you have to be very specific with your prompts, be very detailed, but then you can only control the prompting, but you can't control the output. Because, again, AI is being trained on large corpora of data. Whatever you prompt it to do, it could transform it into something that you would never have guessed would be transformed, because it's learning from the greats, to be honest. We have data from some of the greatest artists, the greatest musicians, that is learning from, and it's able to produce new and inventive art and music and all these literary and creative works that, to be honest, as we go further and further into using AI, the output is not going to be something that we can control. But the other approach that copyright offices are using to determine whether or not to grant authorship in AI-assisted works is human contribution. They require now that there must be substantial human contribution in the AI-assisted, and this is really tied together with the separability doctrine, or the fact that you must be able to separate the human effort from the AI enhancement. But the problem with the human contribution requirement is that it's not precise. It just says there must be a great degree, a substantial degree. It must not be de minimis, so that it's too little that you can't tell that a human being was part of the process. An example here is Zaria of the Dawn, a graphic novel that, again, the United States Copyright Office had granted the copyright in this. So a gentleman goes to Midjourney, creates a graphic novel. The US Copyright Office grants the copyright in the novel in 2022. In 2023, it reviews the decision and revokes the copyright in parts of the work. What it did was maintain the copyright in the text and the arrangement, and then revoke the copyright in the graphic novel itself, because it said that there was a significant distance between what the user directed the AI to do and what the AI actually did. So what the approach it took in that case was a commission work approach, where you commission someone to do the work, and the prompter or the AI user becomes the commissioner, meaning that you gave a person an idea which copyright does not protect, and then the AI becomes the commissioned artist to come up with the final result, and then that now is not protected under AI, under copyright rather. So what we are seeing is a sort of going through the old sweat of the brow, meaning the hard work to come up with the work, or the sweat of the brain, meaning the actual intellectual creation, and the skill of the brush, which is the technical expertise. Those are the questions that are currently arising. And these legal approaches, right now we do not have a precise level of determining what the human contribution to an AI is. There's no parameter. So it's on a case-by-case basis. But the fundamental point is that the human authorship must be separable and distinct from the AI enhancements. And so in terms of, so the other approach is looking at AI and human authors as collaborators, in which case they would have joint authorship. That has been completely rejected so far. The decisions saying you cannot be a joint author with an AI tool. You have to identify a human author who will own the copyright in the work. And for non-human authored works completely, those are not copyrightable. This we have seen from the age-old monkey selfie case where several activists sought to agitate for copyright for a monkey, alleging that it had taken the selfie. But also in Taylor and Palmater, where he claimed that an AI tool had completely generated the work, and again, the question of the need to identify a human author to whom the copyright officers can ascribe the rights in the work. What has developed is a 4-step test to determining these questions, and this 4th-step test involves identifying what tool has been used, who the user is, and again, level of human involvement and contribution in determining whether a human was in fact involved. And that is on authorship. One thing that we tend to confuse for the other is the two concepts, authorship and ownership. Authorship is who authored the works, who came up with the works. Ownership, on the other hand, is a property question, because an author need not necessarily be the owner. Because again, like we mentioned, copyright is a property right that can be sold, that can be assigned, that can be transferred. So the copyright owner has the right to exploit the work commercially rather. And what is growing here in terms of ownership is an important thing to consider is the terms of service of these different AI tools. If you're using AI tools, please, 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 I know it's a very good temptation to accept, but please read these terms of service. I'll give you an example. Midjourney, for example, tells you that you can own, if you generate output, which they call assets, using Midjourney, you can own them. But if you want to exploit them commercially, for example, if you're a company that has a gross annual revenue of $1 million US, there's criteria before you can commercially exploit. You can commercially exploit your assets. And on top of that, you agree to grant Midjourney a worldwide, perpetual, all those words, license to use the works to train their tools and to get better. So in essence, are you really owning the works? Can you really commercially exploit them if at the end of the day you have to seek these people's permission, the AI owner's permission? And on the other hand, ChatGPT has an opposite approach. What it does is it tells you that you own the rights, and it will assign to you any rights and interests it might have in the works. That's their current policy on AI-assisted works. But again, the challenge is these terms of service might be there, but enforcement, how then do you go and start to enforce these rights? And before we get into privacy in AI-assisted creativity, I'd like us to stop and think about what all of this means, because it's so easy to think that creativity is so far removed from us as lawyers, for example, and yet copyright protects everything. The letters you write, even things like written submissions for court matters, all that is copyrightable material. And we are using AI all the time. If you are prompting, if you're interested in copywriting your works, you need to control the process as much as you can. Control the prompting, control what the final output would be like. In fact, I'd ask that you stop and look at some of these. If the cyborg application, for example, what the person did in that case was ensure that they had drawn a real outline of a cyborg, so that the AI's contribution was quite minimal. Even in the final product, you could see the human ingenuity and creativity that this person had invested in the work. So the thing is, AI uses, it trains on large data sets, and the input, and before you talk about the input, the training data itself, but also the prompting. I have heard from people about how they go to ChatGPT and tell it their personal issues, or you're working on a brief and then you get a client's personal data and you just drop it into the AI tool. The internet does not forget. That's the one thing we should always remember. And this data usually entails both personal and identifiable data. AI is able to collect images of real people, voice data, and names. Some of this information is public information that's accessible anywhere. Log data, usage data, device information, location information, all this is very, very sensitive, personal and identifiable data. And there've been a number of complaints against ChatGPT, for example, and GDPR in Italy about how they handle this personal data, or Lenza AI and how it uses personal images and likeness of real human beings, or voice cloning, where voices of celebrities and very important people are used and over things that they have no control over. So what is in place now is we're applying broader data privacy principles, things like lawfulness and purpose limitation and data anonymization. But these things are inherently insufficient because there's only so much you can do. And so what's growing is AI-specific regulations, like the EU AI Act, requirement on mandatory disclosure of training data, for example, or China's deep synthesis regulations. And so these AI-specific regulations allow that you're not operating in the broader data privacy principles, but these are more geared toward addressing the different concerns, the different diverse novel concerns that AI is coming up with. And some of the emerging approaches to data privacy in the age of AI are things like synthetic data generation, where these AI tools are now coming up with, to put it simply, artificial data to rely on as opposed to real data, and things like federated learning and the right to be forgotten. That is, you have the right to request the AI tool to delete your data. The problem, again, is enforcement, because these seem like band-aids to keep us appeased. And so we'll look, as we go on in this discussion, I'll be talking about, is it practical? What can we do instead? Or things like watermarking for traceability. One of the biggest challenges for AI is liability, in terms of if something goes wrong, who is responsible? So one of the emerging trends to trace where a work has come from is AI watermarks. And these are machine readable, codable, that they put on AI generated output to know that, for example, this came from this particular AI. And so if something goes wrong, you can start to determine liability from there. You have a starting point at the very least. And you can't talk about privacy without talking about whether or not you, as a user, get consent for an AI to use your data. And one of the things that is very prevalent is using terms of service as manufactured consent, in the sense that AI tools give you an opt-in, opt-out option. If you don't agree to, terms of service are an agreement at the end of the day. but it's not an agreement you can negotiate. Either you are on board or you're not. And so what usually happens is we just say, I need the tool, I need to use it, so I'll say yes. But then these traditional approaches of saying, these are the terms of service, agree or don't agree, are not, they're proving inadequate in the age of AI, because think about that kind of consent, for example. Sometimes there are tools that will say you consent once to any improvements, you have consented. Others might say every time you update, you agree or accept new terms of service. But the challenge here is it's not feasible, because AI is still, it's growing, it's learning, and you can't consent now to future unknowable uses. And it's even worsened by the information asymmetry. The AI tools have all the information on how they're going to use this data, and the users are completely in the dark. So free and informed consent is not, in fact, something that we can achieve with the traditional approaches to consent. And one of the biggest shortfalls there is that these AI tools are looking at learning as fair use, that we're using this data to learn and be better. But at the end of the day, these are commercial enterprises that are reaping commercial benefit from training on all of this data. The other underlying assumption that is inadequate is that outputs determine legality, in the sense that once the output does not infringe on an original, then it should be okay. And yet that again does not imply consent. So the approaches that are emerging to respond to these AI-specific consent concerns are things like mandatory transparency requirements under, for example, the EU AI Act, for AI tools to disclose. And the other is various forms of AI content licensing arrangements, where you have to get licenses for copyrighted works. The one that I think is very effective is the collective bargaining agreements. In 2023, SAG-AFTRA had entered a collective bargaining, an agreement by which they allowed that AI would not use their material and reap commercial benefit on it without their consent. And what this did is that by coming together, as opposed to, you see that at the end of the day, the challenge is that we are trying to use existing laws that are very individualistic in terms of their protection to govern AI that is training on billions and billions of data. So at the end of the day, as a single person, if you're trying to enforce your individual rights, it might not be as effective, because if you decline, then you decline and AI trains on any other data that's available. So the benefit with these collective bargaining agreements is groups of people can come together and secure protection that has industry-wide effect. And then it's easier and better for these AI tools to obtain consent. The other is voluntary opt-out registries. And these are growing quite widely, where owners of copyrighted works publicly declare that they wouldn't want AI to train using their data. And so they use machine readable protocols, and AI is able to identify those who have entered onto voluntary opt-out registries. And some of these are radical approaches that I think are better suited to respond to the consent concerns, in addition to the traditional approaches, of course, but I believe that traditional approaches alone are insufficient. So where do we go next? The Parliament of Uganda is currently going through an amendment process of the Copyright and Neighboring Rights Act. And I think that it positions Uganda as a copyright leader if we're able to prioritize creator protection and put up frameworks that allow for moral rights enforcement and benefit distribution in AI-assisted works. But also, there must be increased judicial flexibility in determining AI authorship questions. Most of what is happening because most laws in very many jurisdictions are the same. Most of them still require an author to be a natural person. But because people attempt to register AI in AI-assisted works, these questions go to courts. And now judicial officers have to apply a very progressive approach and very progressive approaches and look at the questions with a modern lens and reimagine and reshape and redefine the traditional copyright principles. So increased judicial flexibility would go a long way, but also balancing creator rights with AI innovation. AI innovation is very important. AI is transforming. What it's doing in the health industry, for example, is very immense, but we need to be able to create frameworks that at the end of the day, even with the increased innovation, the creator rights are important, because at the heart of it, copyright law aims to protect and reward human ingenuity and intellectual effort, but also robust consent and privacy frameworks. Some of the lessons we have seen from these different jurisdictions that are crafting, and that was just a few examples, but many jurisdictions have now crafted AI-specific responses to the concerns that are arising, and putting in place these robust consent and privacy frameworks would go a long way to free informed consent for training data for these AI models, but also ensuring that privacy is very key. The Constitution of the Republic of Uganda guarantees the right to privacy, and that even applies in digital form. And also, at the end of the day, ethical AI use. We keep talking about this all the time, but things like mandatory disclosure, things like transparency, and knowing that we can't go on as we have, and that something has to change in terms of how we use disclosure. I think this could be I'll give you an example for AI, for ethical AI use. When I was coming up with this presentation, I did the research on my own, but composing the presentation, I used AI. I used Microsoft Copilot to come up with the presentation. So things like it just goes a long way so that the person you're interacting with knows what to expect. We've seen most recently, Deloitte, and how it was fined for how it had to pay a fine for using AI to generate a report. So it's on each one of us to enforce most of these things, but it needs to be a collective action, because what is working now is the class stratified people who are able to come together and agitate, which is why class actions are able to get better results than individuals trying to fight some of these tools. So I'd just like us to think about all of these questions: authorship, ownership, when we're dealing with AI, your privacy. Do you consent to some of these things? I'd like to also thank KTA for inviting me. It's been the absolute pleasure talking about this, and I welcome any questions you might have.
Thank you so much, Olga. That has been quite comprehensive, a discussion. I have one question. Based on the discussion on emerging approaches and looking at it from the Ugandan context, how practical do you think those emerging approaches are in the local context, Uganda to be specific? How practical do you think those are?
Thank you very much for that question. And it's something that I also think about quite a lot. The practicality of some of these emerging approaches. In terms of authorship and ownership, I do not know of any Ugandan decision regarding AI-assisted works. But privacy and consent, I would say they apply, because I'm not sure which AI tools you use, but for most people, the most common is ChatGPT. And ChatGPT works whether you're in Uganda or you're not. And these approaches, we've had decisions. There was a recent decision, I think early in July, against Google. And I was speaking to the person who had filed it, and they said, what people usually worry about is taking on these big giants. But the Data Protection and Privacy Office actually gave a decision against Google in Uganda. So sometimes I think we hold back thinking we're just too small. There will not be any real effect. And yet if we continue, but things like collective bargaining agreements, I'd say they are still applicable even here, because these tools are training on data from Uganda. So it's up to us to enforce our rights in the copyright existing in those works.
All right, thank you so much. Just need to know if we have any questions from the audience. Is there a way we can find out whether there are questions? Those are the only chats? Are those the only chats that we have? Okay. All right, so we have a question from Henrietta. Says, thank you, Olga, for this very insightful presentation. What are the potential areas for litigation in AI? Yeah, that's the question that we have.
Thank you very much, Henrietta. Potential areas for litigation in AI, copyright infringement currently, because at the heart of it, AI is training on existing data. Some of it is in the public, but some of it is work that is protected. So there's a lot of litigation on these cases against AI, OpenAI, for example, Stable Diffusion, and the litigation is immense, but also on data rights. One of the cases I highlighted was the case against ChatGPT in Italy, for example, on their use and disclosure of personal data without express consent rather. And so the litigation is growing as we continue to use AI, but most of it in terms of copyright is on infringement and data disclosure with unconsented data disclosures.
Okay. Another question that we have is from Dr. Hilda. How do we as a country adapt the current provisions to protect AI copyright infringements?
Thank you very much, Hilda. As a country, current provisions on copyright infringement need, like I mentioned, the Copyright and Neighboring Rights Act is undergoing an amendment process. And I think it would be important for us to address these concerns that are rising, especially with AI and how it is infringing on copyrighted data. And some of it would be to provide that in the act, to put that in the act. For example, where an AI tool requiring mandatory disclosure. And the best example I can use is in the EU AI Act, the requirement for mandatory disclosure of training data. What are your sources? What are the limitations? What are you using it only for? Because you need to properly specify that the data, for example, will be just for training, and putting in place licensing agreements for people that own copyright to license its use in training to AI. So enforcing licensing arrangements, but ensuring that it is clear in the law that copyright infringement, even for AI training, is prohibited, I think would be a great starting step.
Okay. Just to follow up on that, would that mean that we're looking at a way of enforcing policy or frameworks within the country just to govern our use of AI?
Yes, I think that would be, I know that there's a policy or strategy that is under that is that's being enacted or worked on. But it would be, I think we're currently in the dark, because when clients ask you what is currently regulating AI, and you talk about Electronic Transactions Act, Electronic Signatures, Data Privacy and Protection Act, those are general. We need an AI specific policy, an AI specific strategy. Those would be starting steps. But even an AI Act, I would say, lessons from the EU AI Act and how they've dealt with these questions on AI has been quite transformative in terms of just being a leader and saying, okay, this is where we're starting from, and then we can move on, because AI is still evolving. We can't say we have definitive positions on some of these questions, but I would say it's a good starting point.
Okay, we'll take one last question, and this is, how do we balance the benefits of sharing knowledge and copyright laws? So I think just the balance between the two of those.
The benefits of sharing knowledge and copyright laws. Thank you, Henrietta, for that question. So here it's this is something I've always thought of, in terms of sometimes you want to keep the knowledge for yourself, and there are different forms of protecting knowledge. For people who want to keep the knowledge for yourself, there are arrangements like trade secrets where you keep the thing for yourself. But copyright is not a perpetual right. It expires. So the copyright laws already envision that there'll be knowledge sharing at the end of the day. Because what happens is you share the knowledge, but because you own the copyright, you are able to commercially exploit the knowledge exclusively. So it helps, if you get a book, for example, the benefit sharing and the copyright enforcement go hand in hand. I will learn the knowledge, but I can't commercially exploit it without, for example, a license or some sort of arrangement that allows me to use from the copyright owner. So I think that both of them are complementary and they must go hand in hand.
All right, since we're not doing well with time, we thank you so much, Olga, for being part of this and taking us through the first part of the session, telling us about ownership and authorship, those two being quite a sticky situation in terms of trying to differentiate the two. Thank you so much. And also on issues of consent. I think as not just Ugandans or lawyers working within the local context, I feel we haven't yet exploited the use of the more emerging approaches and modern ways of figuring out how to deal with consent, especially in the emerging eras. So just to conclude this, we're going to have a short sort of 5-minute break just to have the next presenter get ready. And yeah, we shall start from there in the next 5 minutes. Thank you. Thank you, Olga. Okay, we're back from the short 5-minute break, and just to the next session. One, we're just from looking at creativity and looking at ownership and seeing how we're able to protect those and what rights the creators of that work have, and also looking at it in line with AI and our use of AI. So our next discussion just brings us a little closer. We are looking at tradition and collective heritage, and also seeing how exploring the legal implications of digitizing the cultural expressions. And so what we're looking at is seeing how do we preserve, how do we protect, and how do we then promote who we are in the digital world, yeah? And so to guide this discussion, I will invite Mr. Wabugo. Mr. Wabugo Michael is a senior registration officer, URSB, particular to the IP department, and he will share insight on how best we can strike a balance between protection and participation in the digital age, particular to traditional knowledge and generally culture in Uganda. Yeah, I will let Mr. Wabugo take the stage.
Thank you, moderator, and thank you for that brief introduction about me. Very excited to be here and excited to share some insights about traditional knowledge and traditional cultural expressions. For the benefit of the online viewers and those physically here, someone will ask what's the role of URSB, or Uganda Registration Services Bureau, in regard to traditional knowledge and traditional cultural expressions. Just to inform you, URSB, like most of you know, we are responsible for registration of intellectual property rights. And like you introduced me, I'm from the Department of Intellectual Property, but under the Department of Intellectual Property, we now have traditional knowledge division where I'm coming from. So as URSB, we've been coordinating and championing enacting a sui generis law to protect traditional knowledge and cultural expressions, and of course under the supervision of Ministry of Justice and Constitutional Affairs. And we also engage and participate in the WIPO committees, specifically the Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge, and Folklore. So today's presentation, or what I'm tasked to talk about, is the legal implication of traditional cultural expressions. And the beauty about traditional cultural expression is that at least all of us have where we come from, or we have a tribe where we come from, or we have cultural heritage. So it's very easy to understand what a cultural expressions mean. This is my my outline of the presentation today. Talk about digitalization. Digitization versus digitalization, traditional cultural expressions, forms of TCEs, characteristics of TCEs, defensive and positive protection, the public domain debate. Then we can also look at the international, regional, and national legal and policy framework, then the legal implications of digitizing TCEs. Now, many times we use these terms and probably we may not understand what they mean when someone may want to mean digitalization, but then they say digitalization. So it's very important to understand the differences of these terminologies. Like I indicate in my presentation, when we talk about digitization, you are changing a process of changing from analog to a digital format, or converting a physical object into a digital asset. And the digitization is usually concerned with capturing information for a digital process. So the purpose here for digitization is usually to ease accessibility and search of digital data. Then when we say digitalization, you are using digital technologies to change business models or processes. And the combination of digitization and digitalization, then you're doing digital transformation. Now, what are traditional cultural expressions? There are different terms to refer to traditional cultural expressions, and you will find these terms in different materials or international instruments, or even legal instruments, national laws. You will see expressions of folklore. You will see indigenous and cultural intellectual property, or you will see folklore and then traditional cultural expressions. But these mean and refer to the same thing. What I know is that at the WIPO engagements and discussions, some communities have not been comfortable to use the term folklore, and that's why WIPO adopted the use of traditional cultural expressions. But then you'll see that at the regional level, that is the African Regional Intellectual Property, there is the SWACOPMA protocol on protection of traditional knowledge and expressions of folklore. They use expressions of folklore. So as lawyers, you also need to be alive to these debates so that you can at least understand the implications. Now, TCEs, or traditional cultural expressions, usually these are creative expressions linked to a community or a collective indigenous community, and that's why they are called traditional. Many times people think that when we say traditional, it is outdated, it's antique, it's it is something which is backward, and that's actually the perception that we also need to change. Saying traditional doesn't mean that something is traditional. Some of these traditional cultural expressions are actually evolving and they are dynamic. So traditional doesn't mean backwardness or outdated. Then the traditional cultural expressions can be tangible or intangible, and usually it's the traditional knowledge that is expressed or manifested. And traditional cultural expressions have a cultural significance or cultural heritage, and they also serve to give identity to a community or to even an individual. So they are very vital and a dynamic part of our lives in many communities today. Now, what are the forms of TCEs or expressions of folklore? We all, like in my opening remarks, I said we have where we come from, we have roots in terms of tribe or whatever you may call it. And there are practices in these communities or tribes where we come from. We do dances, we dance, we recite poems or riddles. There are handicrafts. There is a way where you come from, the way your people dress, or your people name, the symbols or the signs. All these are what we call traditional cultural expressions. They are expressions, manifestations of the knowledge, of the traditional knowledge held by a community or a particular group of people in a community. So they are tangible expressions, such as they are tangible expressions. Like I said, the TCEs can be tangible or intangible. Then the tangible ones, those are the crafts, the dresses, the symbols. When you go to the Baganda, you'll see the traditional symbols or the symbols of the kingdom. Then the dances, the stories, the poems, riddles, those are intangible aspects of traditional cultural expressions. Now, what are the characteristics of TCEs? Usually, these are products of creative intellectual activity or products of ingenuity, what we can call as intellectual property. And they are passed from generation to generation. So what we can, the dances that we have today amongst the Baganda or the Bagisu, where I come from, these have been passed from generation to generation, and they embody culture and social identity. Many times the TCEs, and that's where the issues of protection come from, is that the authors are unknown, since these are inherited assets. So you can't know the author of a particular song, you can't know the author of a particular story, and they are usually oral. They're not in written formats. Then TCEs actually rely largely to use natural resources. The crafts that you see in the market, the crafts that define the Chiganda culture or the Toro or the Ankoli culture, you know very well that the materials are sourced from natural environment. These are plants or trees or whatever. So basically, these are some of the characteristics of traditional cultural expressions. Now, in terms of protection for TCEs and traditional knowledge, if I can say, because TCEs are actually a subset of traditional knowledge. We usually talk about traditional knowledge to mean even TCEs. So we have what we call the defensive protection or the positive protection. And when you see the defensive protection, the aim is to stop the outside community from acquiring intellectual property rights over TCEs. Things like creating or establishing registries or libraries. A country like India or China, they have actually advanced in respect to protecting their traditional knowledge and traditional cultural expressions. Now, India has a digital library, and that digital library has all the forms of traditional knowledge or TCEs of the Indian communities. And this digital library actually has been translated, I think, in 6 languages. And the purpose is actually to prevent granting of erroneous patents, and to ensure that the traditional knowledge of the Indian community is preserved and protected. Then there is documentation. This documentation can facilitate in providing confidential or secret record for traditional knowledge to relevant community only. Now that is a defensive protection. Then when we go to the positive protection, positive protection is grants rights that empower communities to promote their TCEs, rights like intellectual or property rights. And this also helps the owners of TCEs to control use and benefits from the commercial exploitation of their TCE assets. Now, this can be laws, rules and regulations, and they also facilitate access and benefit sharing arising from the utilization of either traditional knowledge or TCEs. And like I said, that as URSB, we are coordinating under the supervision of Ministry of Justice and Constitutional Affairs to enact, to have a law that can protect traditional knowledge and traditional cultural expressions. Since when you look at the existing IP regimes, the traditional knowledge and these traditional cultural expressions may not actually be adequately protected. Yeah. Now, I want to talk about the public domain debate, and this is a very, very hot issue at the international forums. Some of these Western countries or advanced countries want to use the TCEs without actually compensating the owners or the traditional communities where these traditional cultural expressions originate. So the debate is these are TCEs, is traditional knowledge, so it is in the public domain, so it shouldn't have protection, so anybody can use it. And that is where the issues of traditional communities and the so-called advanced economies come from. They say no, our TCEs or traditional knowledge is not freely available for any person to use. Yes, they have been in existence for over centuries, for over generations, but there is a community that at least owns these traditional cultural expressions. And it is important that if someone wants to commercially exploit or use or benefit from some of these TCEs, then there should be some equitable remuneration or some sort of benefit sharing. So, and it is because of this public domain debate that we've seen many international instruments being adopted to see that the indigenous people, the traditional communities that own these TCEs are adequately protected, or their rights are recognized and respected. So the public domain has three perspectives, and these perspectives on the legal status of the materials, of the freedom to use materials, and the availability of accessibility of materials. Now, the legal status of materials, for instance, when we are talking about the public domain, let me give an example. For a patent, it has been, if it has been protected for 20 years, and after 20 years, then it falls into the public domain. That's the legal status. So it will not have IP protection. Then freedom of use of materials, since TCEs say they are freely available. So there should be freedom of people to utilize these TCEs. Then availability and accessibility of materials, the nature, the ease of access and availability of such resources sometimes make people or some to think that actually these materials are in the public domain because they are available or they are easily accessible. Then the people who support the public domain are accessing the TCEs say if we restrict access or utilization of these TCEs, then it would stifle innovation and creativity. So they argue that there should be that freedom to use these materials so that so that there is some kind of stimulation of innovation and creativity by using the existing TCEs to come up with new inventions or innovations. And then innovation depends upon the existence of a rich public domain. Those are some of the arguments fronted by the proponents of the public domain argument. However, there are, of course, protocols or laws or even international legal instruments that have enshrined the aspects of prior informed consent, mutually agreed terms, and equitable benefit sharing. For instance, the Nagoya Protocol, which is a supplement to the CBD or the Convention of the on Biological Diversity. These are some of the international, regional, national legal and policy frameworks that have, and they are quite a number, but these are some that I at least highlighted for purposes of understanding how these TCEs are actually protected at the international or the regional and then the national level. But we can talk about the national legal and policy framework of Uganda. Of course, the Constitution of the Republic of Uganda. We have the National Intellectual Property Policy. We have the National Culture Policy. Though this culture policy is being revised, it's being updated. Then the Copyright and Neighboring Rights Act. At least the previous speaker was talking about copyright, and this act actually provides folklore as a subject matter for copyright protection. And then the Industrial Property Act, which has mandatory disclosure on in case an inventor has used a genetic resource or associated traditional knowledge. And then trademarks. Now trademarks, since it protects signs, symbols, names, we've been receiving from the regulatory perspective or from the URSB perspective, we actually receive applications for trademark registration of traditional symbols, traditional names, and some have been coming from the cultural institutions in Uganda. So you can see how these are very, very fundamental issues for communities that own them. Then the Trade Secrets Protection Act, protecting confidential or commercial information, Then I will talk about some of the legal implications. Like I've noted that digital technologies, and more specifically the internet and the web, have actually created or eased ways of creating content disputing content, but also preserving content. Now, in that process, there are quite a number of legal implications, which lawyers need to understand. These digital technologies have, like I noticed in the second bullet, created, disseminating, and access or consumption of TCEs. Then the main issues in respect to TCEs actually come in terms of protecting IP rights, in terms of copyright, the folklore. If you're digitizing, who owns the aspects of ownership, aspects of duration of protection, aspects of what's the objective of digitizing some of these TCEs, and you can see that in the countries that have created the databases of traditional cultural expressions and TK, the creators of databases actually will own the IP rights in the database and not the information that has been recorded in these databases. And those are some of the issues of IP, I mean copyright protection. Then things to do with data protection and privacy rights of these owners of traditional cultural expressions. How are their rights respected, and how are their privacy? Because there are aspects of traditional knowledge or traditional cultural expressions that are sacred and secret, that there are protocols to use some of these the TCEs that are regarded as sacred in terms of religious and spiritual aspects. Then there are those that are secret, that they are owned by specific custodians of culture in a community. And to pass over some of these TCEs or to disclose some of these TCEs violate the protocols or the customary laws of particular or specific or relevant communities. Then issues to do with the human rights and most of the international instruments to protect or traditional knowledge or traditional cultural expressions actually have a human rights perspective behind them to recognize and respect the rights of indigenous people. Then things to do with digital rights management, where they create, provide measures to define and control rights of access and dissemination of some of these TCEs on the internet or on the online platforms. Those are some of the legal implications, but they could be quite many. And then probably what I can also talk about the benefits of digitization, and this can come from what's the objective of digitizing. Is it to preserve? Is it to promote? Is it to commercialize the TCEs? So these are aspects that have to be considered. Now, there is the WIPO Treaty on Intellectual Property, Genetic Resources, and Associated Traditional Knowledge, which Uganda ratified a few months back. And in that instrument, there is a provision of establishing digital databases or registers to actually record TK traditional knowledge of indigenous and local communities. But The emphasis in that provision is that in creating or in establishing some of these digital databases or registers or whatever you can call it, the local communities or the indigenous people who own these TK or TC, it doesn't talk about TCEs, but I can to add TCEs my own. The indigenous communities or the local the indigenous peoples and the local communities have to be involved, to be consulted in establishing some the databases to record the TK. So it is very important that the traditional, I mean the communities, the local community, the local peoples and the indigenous communities have to be involved in these things or in the process of digitizing, so that whoever is digitizing has to get prior informed consent from the owners of these TCEs, but there should also be some kind of agreements, or contracts or protocols between the person who could be digitizing and the owners of the TCEs. Probably there are issues that can arise or risks that can arise in digitizing the TCEs. For instance, issues of data authenticity and integrity, issues to do with manipulation or disrespectful manipulation of some TCEs. And I think with this AI all over, you've seen videos recreating or reenacting stories of Kintu, whatever. So you can see how the digitization can, in a way, also impact. But the issue here, what I want to bring about the risk is that some of these digitization acts can actually manipulate or mislead or give even misleading information about TCEs. And these are ESCO issues that need to be, ESCO and legal issues that need to be given due consideration. Then harmful commercialization of, these TCEs. Yes, that's my presentation, and thank you so much. I welcome some questions. Thank you.
Okay, thank you so much, Mr. Wabugo. That has been quite an interesting discussion. I have a few questions of my own, but I do also realize that we have a set of questions that have been sent on the chat. So I will ask, how does consent look like? You've spoken of consent from the traditional, the owners of the TCEs and whatnot, and those that are digitizing. How does consent look like? I have quite a number. That's just one. The second one is based on the public domain debate that you spoke about. Do we have any expressions of folklore, folklore itself, or traditional cultural expressions that have been registered in Uganda, at least in the last 3 to 5 years? How hard is it? Because at least now we know that with URSP, it has made it much, much easier to register copyrights. I think even with the last amendment we had, it's easier to register copyrights, trademarks. That is how easy. I'm going with easier, not difficult. How easy is it for us to register and get those registered? And lastly, is there any legal challenge or ethical dilemma that exists in the digitization of this of the TCEs and of traditional knowledge that is faced by communities, since they are the general custodians of this traditional knowledge and whatnot? Those are my questions, and from that we shall go to the platform and see what questions there.
Thank you, moderator. Let me first answer the question on consent. How does it look like? I actually talked about it in my presentation. prior from the consent. And usually, before you access or utilize a TCE, you have to get some kind of consent from the community that owns these TCEs. And communities, actually the indigenous peoples or local communities, will always have custodians of these traditional cultural expressions. Now, like, I can give you an example of the Buganda Kingdom. The king is the custodian of culture in Buganda. So if you are to get consent, and then there are those clans or whatever. Now, if you want to, let's say, use some kind of traditional knowledge or traditional cultural expression from a particular clan, then you have to get some kind of consent from probably the clan head or even the king himself. And this in this consent process, there can be some kind of written agreements. That's if it gets up to that point. But there are also customary laws that govern how to access some of these traditional cultural expressions. So before you do a certain act, or before you access a certain kind of TCE or traditional knowledge, there is some kind of rules or protocols that you have to follow before you can use. So that's what can actually define the consent, or how consent looks like. Then public domain, how is it? Is it register a traditional cultural expression in Uganda? URSB, like you know, it will register intellectual property rights, and a few months back we've been doing reforms to ensure that our stakeholders can access the registration services easily. And because of the need to also boost the creative economy and also have reforms in copyright protection and enforcement, the government, or URSB, established the copyright and neighboring rights department. So it's now separate from the main intellectual property department. And we register copyright of works that are eligible for copyright protection. And like I noted in the Copyright and Neighboring Rights Act, folklore is a subject matter that can have copyright protection. So if you're talking about copyright registration, there are forms that an author fills or a creator fills, and then pays a very small fee of 50,000. Recently, the minister removed the requirement for gazetting. Before, you were required, whoever wanted to register copyright was required to do a gazette publication, but now it's no longer required. So once you apply, pay your 50,000 for a song or a performance, then you can have copyright registration. Then are there any challenges and ethical dilemma in
the digitization? The digitization process?
Yes, there are legal challenges of ensuring that data is protected, data from of the communities, and then their privacy. I talked about the TCEs, or traditional knowledge, which is sacred, and you can't just disclose it anyhow. There is a case in Australia. It was Foster versus Mount Fond, where an anthropologist went into a community, collected information, and this information was sacred. Then he released a book. And the council of the indigenous community whose information had been disclosed had to take this anthropologist to court. And the Supreme Court definitely ruled in favor of the communities and issued an injunction against this anthropologist from publishing or reproducing those books that contained sacred information. Yeah, in Uganda, I've not come across a case of that nature, but the legal implication, the legal challenges are there, and also the ethical challenges. Now, I talked about manipulating some of these stories to suit, the views or to suit the interest of the people who are going to view the videos that have been reenacted or created by AI. So those are some of the ethical challenges that can come up in this whole thing. Yes.
All right, thank you. Now we'll just switch back to the platform and see what questions are there. I think there was a first question from Dr. Hilda. If we could just go back to that one before we move to the next. Yes. Okay. So for the presentation that we've had on traditional knowledge, how questions are. She has 3 questions. One is, have there been any litigation to protect indigenous knowledge in Uganda? The second one is, do we have benefit sharing agreements between producers of shea butter in the north and eastern shea butter belt of Uganda? That's the second. The third is, please enlighten us on any awareness creation efforts by URSP regarding the protection of traditional knowledge in the AI space. If not, is there funding or some form of partnership with the private sector? I hope you have answers to these ones, Mr. Wabuko. I think we should take all the questions. We could just scroll up so we can take all the questions. The next one is, before protection, there's got to be something to protect. TK and traditional knowledge expressions have been threatened by cultural erosion and dilution in the internet age. How is URSP planning to engage and encourage stakeholders, kingdoms, chiefdoms, schools, dramatists to popularize the TCEs since they can now get protection? All right, those are the questions that we have. I hope you've...
Thank you for those questions. The first question on any litigation or traditional cultural expressions. I'm not aware. That one I don't want to to lie to you that I'm aware of whether there is any litigation from an indigenous community or local people litigating over their use of their TCEs, unauthorized or misuse. That one I'm not aware about. I can't state that it's there. And probably we might see these litigations coming maybe when we get a sui generis law that protects traditional knowledge and traditional cultural expressions. Then whether there are some benefit sharing agreements of shea butter and shea butter in the northern region. Shea butter, the shea butter comes from the shea nuts, and these trees grow in the wild. What I know is that government has, because the the trees, I understand. Okay, the shea butter from northern Uganda has a certain unique quality as compared to the shea butters from other countries like Ghana. They say our shea butter is good for cosmetics. Yeah. However, there have been threats on the trees, the shea nuts, because people cut them to burn charcoal. And the government, I think, has been trying to see how to control that. But there are also various interventions from international organizations or NGOs to support and protect the shea nut tree from extinctions. Now, since these trees grow in the wild, the communities are free to, people are free to access some of these products or the shea nuts from these trees. So I'm not aware of any benefit sharing agreement between the community and the people who are using the shea nut to extract shea butter or shea oil. Now, as URSB, we also have plans or interventions of protecting the shea butter from northern Uganda as a geographical indication. And that process is in the pipeline. Soon or later, let me say soon, we shall have at least a geographical indication protection for shea butter from northern Uganda. And this also helps the community to leverage on the IP assets or the assets that they own to create value. Then awareness on AI, yes, URSB conducts many awareness programs, engagements with stakeholders. So the awareness is there. Funding, I'm not sure about whether there is any funding to support whatever activity the person who asked this question, because URSB is not URSB is the what we do is we provide technical support, but we don't provide financial support. Yes. Then how URSB plans to engage kingdoms? Yes, we've been and we continuously do engage the cultural institutions. Our section of the traditional knowledge where I come from, we've engaged many almost all the cultural institutions in Uganda in terms of consultations on some of the policies or the laws that protect IP. So we've engaged them, and we have more and more plans of how to support the kingdoms or the cultural institutions to actually protect their IP assets. Yes. I think that is it, unless there is.
All right. Thank you so much. I think this brings us to the conclusion of this presentation and this part. Thank you so much for joining us, and thank you for being part of the discussion. I think my last issue, I think, would be on the fact that someone was talking about how we have quite a number of laws, right? And so if we keep creating more laws, isn't there a way that we can create something that's merged? Something that, you know, if you're talking about how we have, I think, cultural laws, policies, practices, something like that, how do we merge those? You know, how do we get even what we have currently in law and create something that's more comprehensive as opposed to creating individual laws? Isn't that something that we can do?
Yeah, I agree with you on that. I think we have many overlapping laws and policies. However, mine will not be actually an issue of having many laws. The issue will be in implementation and enforcement. So to me, that's where I think we can put emphasis on. Not how many laws we have, but are we implementing them and are we enforcing these laws?
All right. Thank you so much. That concludes this session. I will have the next session in the next 5 minutes, just a little break for the transition to happen. And we'll have the next session that's going to be chaired by Mr. Kenneth Mohanji. And this is the part that I leave. I remain Catherine Akankwasa, the practice head and senior associate of the Technology, Media, Telecommunication, and Sustainability Department of KTA. I will return once Kenneth is done with his part as well. All right, see you in 5 minutes. Bye.
Are we good to go? Okay. Good morning again, Mkomiewu, and second edition of this panel that we are going to talk about more topics that relate to digital trade, that relate to. Are you going to talk about AI, Mebo? No, mostly digital trade. Okay. Like we said, I hope you've enjoyed the past sessions. They were very informative. I liked the discussions on traditional culture expressions. I hope you saw that there are many opportunities for lawyers to be able to expand into those areas. We still have, it's still a nascent field in as far as regulation is concerned. So all of those are opportunities. If you're interested in policy, if you're interested in trainings, if you're interested as well in helping these communities to be able to register their TCEs after we have a legal framework completed. Of course, we already have the framework for geographical indications. So I hope you have picked up a number of things or two. But even outside of that, just general knowledge that you can be able to use when you're conversing with whoever you're conversing with regarding what it means to have traditional culture expressions. And then, of course, before that, we had from Olga on artificial intelligence and copyright and what it means to have AI-generated works. We are seeing that more and more of you are using these platforms like ChatGPT, Microsoft Copilot, Gemini, and all of these AI applications. So what happens if you're creative, if your client is a creative and they create work by using artificial intelligence? Does that work, do they own that work? Is it the AI that owns, is an AI a person? What happens like in that instance of the song with Azawi, Masavu, that where there was a remix that was created by AI, where they recreated the voice of the late Mose Radio. In that instance, how can the estate of Mose Radio recover if there's any money or any process that have been made in that regard, or if they feel like the voice of the deceased has been used without consent? So we discussed all of those, and now we have pivoted into Sente, money. And so with me, it's my pleasure to introduce my dear friend and colleague, Mebo Chisaka. Mebo is a very big woman. She's holds an LLM in International Business and Economic Law from Georgetown. She holds a Bachelor of Laws from Makerere University, a Diploma in Legal Practice from LDC, and she's currently the Managing Partner and Head of Corporate Finance, Corporate, Commercial, and Project Finance at Mesa Advocates. She has consulted with the World Bank. She's also undertaking a consultancy with Trademark Africa on digital trade. She's currently also the chair, by the way, of the, is it digital trade or international trade and regional integration at the East Africa Law Society. So she's representing you there on that platform. She has several certificates in legal tech and digital transformation from other universities across the world. She's also a mediator, and she has a lot of experience in digital trade. She's also with us at the Alliance for Digital Trade, E-Mobility and Careers Association, where we are looking at advancing digital trade across the region, and in particular, that issue of cross-border trade. She has consulted with COMESA. So really, you who is listening, there is a lot to learn from Mebo, and I will not take up too much time other than just to ask her to share your nuggets of wisdom with our advocates, and then we can be able to have a short discussion after that. Thank you.
Okay, thank you so much, Ken. I'm going to request you to help me move the slides. I'm going to refer to my laptop because I can't see far. So mine is simple. Mine is to give a guide to cross-border digital trade in East Africa, Africa, but then not forgetting Uganda. So digital trade includes e-commerce, online services, cross-border payments, and data flows. If you look at the trend of digital trade, you'll notice quickly that it's growing worldwide and holds strong potential, especially in Africa. So in East Africa, currently we have a growing rise in mobile use, mobile money adoption, logistics, digital logistics, regional initiatives. We have the East African Community e-commerce strategy. We have the African Continental Free Trade Area, the Digital Trade Protocol under the AFCFTA. And these are creating business opportunities, but however, we cannot talk about them without talking about the current challenges that we have, which include limited or poor infrastructure, weak payment links, digital skills are still lacking in the region. And in all this for lawyers, this means that we have a great and an important role to play, which is guiding clients through complex and evolving environments that require expertise in digital trade, data protection, payments, consumer law, and regional integration. So I'm going to go through a few of the regional legal frameworks. And in East Africa, I'm just going to summarize this. In East Africa, we have the e-commerce strategy. And this strategy was passed to enhance the legal and regulatory frameworks and trust in digital e-commerce across partner states. So, and on the African-wide part, we have the AFCFTA Protocol on Digital Trade, which addresses digital payments, e-commerce, data flows, emerging technologies, and so much more. So under that protocol, customs duties on digitally transmitted products are prohibited. So under the AFCFTA trade in goods and services, duties are prohibited for actual goods and services, the physical goods and services. So the protocol on digital trade prohibits duties on digitally transmitted goods and services. And again, when we look at digital trade, we are not looking at only trade in goods. We are looking at both trade in goods and trade in services. So on a regional level, that is, that's the regulatory framework. And in addition to the various countries have their own regulations, and we shall go into that and seeing how we can align the national legal framework with the regional frameworks. So, so what are the implications of this to a Ugandan-based lawyer? So with the regional frameworks in place and us talking about cross-border digital trade, you must keep abreast of both the national and regional digital trade regulations and obligations. And this essentially affects how you draft your contracts, how you advise your clients on compliance, and we shall get into that. But before we get into that, I wanted to sort of give you a highlight of where we are as Africa in terms of digital trade. There are so many frameworks that have been created at a regional level to support our digital trade agenda. So several digital frameworks have been developed in Africa to streamline cross-border commerce and enhance regional integration. And some of these, we have the EAC Single Customs Territory. So this offers significant benefits, including cutting reduced trade costs and time, simplified procedures, transparency, and enhanced trade facilitation. So now, with digitalizing trade facilitation, you find that when you bring in your goods probably at Mombasa, you're able to clear them at Mombasa without coming to you, without the goods entering Uganda. So it's so the interconnected customs systems and regional electronic cargo tracking system enables real-time cargo monitoring, improved transparency, security, and information sharing. So under the EAC, we have really done well when it comes to digital trade facilitation. We have really, really done well because now you can clear goods under that same system. You can track the goods under that same system. So this has been one of the achievements, I should say, of the EAC. And then when we look at Africa as a whole, we have what we call the Trade Observatory. So the Trade Observatory provides benefits such as offering timely data analysis for better policy making. It helps businesses identify new opportunities and navigate market access. And it provides evidence best support to your trade strategy. So let me give an example how the Trade Observatory works. So if you want to source for raw materials within the African Continental Free Trade Area, you would have to, you can go to the Trade Observatory and you will know which country in Africa has these raw materials and or the cheapest raw materials. Then you, even for markets, you can know with the Trade Observatory, they collect all the data and you're able to know where to sell your coffee, where the demand is. So at the African level, they've created these systems to help monitor trade, but also trade agreements, because there are so many agreements that are being signed left, right, and center. Bilateral agreements. Recently, we had a bilateral agreement between Uganda and Algeria. So under this framework, you're able to know the various laws, because as a lawyer, as you're advising your client who is trading under, let me say trading with Algeria now, is it best for them to trade under the AFCFTA or trade under the bilateral agreement? So you find that the recent company that did a consignment of milk with Algeria, they opted to do the consignment under the bilateral rather than the AFCFTA, depending on the benefits that best suit your client. So that is what the Trade Observatory does. So it can help you with that research. You don't have to go into the law books and check, and that has been simplified. Then, in addition to the Trade Observatory, at the African level, we have what they call the ATEX. The ATEX is a B2B platform that supports the AFCFTA by boosting intra-African trade. This helps with optimizing supply chains, accelerating economic growth through a digital marketplace that connects businesses across the continent. I like calling it the Amazon of Africa. So at the African level, they have created the ATEX. So with the ATEX, businesses can sell their goods throughout the region. So in other words, if you want coffee, all you have to do is have the app, just like you have the Amazon app, and then order for whatever you need within the region. And I know some of you may be asking, so if we order, how do we pay? So I'm going to go to how the payments are done. So what has been developed at the African level is the Pan-African Payment and Settlement System. We call it the PAPS. So the PAPS enables instant or near to instant fund transfers between senders and recipients across African countries. And this helps in accelerating cross-border payments by connecting so the PAPS works in conjunction with commercial banks in various countries, commercial service providers, and other financial intermediaries. And with the PAPS, you have reduced costs and complexities of foreign exchange transactions. In other words, with the PAPS that has been created, your money doesn't go to New York, then you suffer the foreign exchange cost and then comes back to Africa. So you get your money in your local currency under the PAPS. So those are there's so much that is being done at a continental level, and I'll encourage you to probably read and stay updated with the things that are happening, because digital trade is here and it's not going away. So those are some of the developments that are coming up on the African level. So I'm going to move, I think, slide 5, which talks about the legal risks and client advisory issues. So when advising clients engaged in digital trade, these are some of the things to assess and mitigate. So on the level of contracting, we need to consider the following. And some of the things we need to consider are electronic contracts and signatures recognized and valid under the Ugandan law first, if it's a Ugandan client, but also if that client is transacting with someone in DRC, are they recognized equally in DRC? So whereas you have your electronic signatures recognized in your country, that alone is not sufficient. You have to ask yourself, the person I'm contracting with, because this is cross-border trade, the person I'm contracting with, are those electronic signatures recognized in their country? Because if they are not, then the contract may not be enforceable. Then for cross-border transactions, you have to look at what laws governs the contract, any dispute resolution mechanisms enforceable across the borders. And because this is contracting in general, you can choose the law, you can choose the dispute resolution system. Then there are some technical issues to consider. How to verify the digital signatures, what authentication standards apply, how to demonstrate the integrity of data. So those ones, and you could consider them. They're not sort of mandatory, but for some clients, they may require that kind of due diligence. And then on data protection and privacy, we have to assess whether Uganda or the partner states have data protection laws. And you have to ensure that you abide to those data protection laws. Like I said, in digital cross-border trade, you don't look at only your country's laws. You look at your country's laws vis-a-vis the country your client is dealing or trading with. And whereas you find that Uganda, Kenya, and some other East African states have adopted certain legal frameworks and laws, these laws are not interoperable. So you have to be very careful to ensure that these laws are interoperable before you advise your clients. So, and then you have to look at whether there are restrictions on data localization, and then under the AFCFTA protocol, data flows are permitted for digital trade except when restrictions are justified due to maybe security concerns by countries. And so as lawyers, we should be able to draft data processing agreements, cross-border transfer mechanisms, and also advise our clients in general on how to handle the data issues, considering all the laws in question. And how I would go about this is first look at the local laws, then look at the regional laws. If it's within the ESC, look at the ESC laws, then look at the individual country laws, and then with that you assess and advise the client. So after data protection, the other consideration you should make as a lawyer is payment systems and cross-border settlements. So with payment system, you look at the payment interoperability, since some are still weak. And like I said, we have what they call the PAPs. The PAPs is working now in some countries. It is yet to work across Africa. So before its full actualization, we need to look at for our cross-border digital clients, we need to assess which jurisdictions financial regulation applies. So all those you need to look at the financial regulation for each jurisdiction and assess what applies. And then the licenses that are required. For example, in Uganda, we have our own licenses that are required under the BOU for those dealing in payment systems. So you have to ensure that those licenses are obtained at a local level. Then consumer protection, on the other hand, online marketplaces and digital platforms face a lot of risks in relating to consumer rights and consumer protection. We have had these stories where people tell you that they saw a very beautiful dress. What they saw and what was delivered was totally different. And on the legal front, as you're aware, we don't have a consumer protection law in the country. And as lawyers, I think we need to advocate for consumer protection, especially in the light of digital trade. So as you're advising your client, we should be able to draft platform terms and conditions aligned with multiple jurisdictions, check for mandatory disclosures, and design policies for takedown, content moderation, data breaches, and cross-border dispute resolution. If you want to handle the issue of consumer protection, because complaints might arise from your clients. Then on taxation and digital services tax, you have to make considerations again relating to taxation. And these ones, again, you have to look at the various countries and at each individual country and what tax applies for each country. However, I would advise lawyers again on the issue of taxation to work with tax consultants so that they don't miss, or if they are not specialized in tax, that is. And then there is IP and digital goods and copyright. So with digital trade, there is often software platforms, digital content, and licensing models. Lawyers must advise on protecting IP and ensuring licenses permit cross-border use, guarding against infringement and counterfeiting. So as lawyers advising clients, you have to try and advise them on cross-border registrations of IP and enforcement, and also ensure that your client's IP can be protected in the country they are dealing in. So in COMESA, for example, they are just developing a system for cross-border enforcement of IP. Some of these systems for cross-border enforcement of IP are not yet in place, so they are currently being developed. So right now, you have to ensure that you abide or you do the necessary registrations in each country, or depending on whether it's applicable or not within that country. Then the other concerns is cybersecurity, digital identity, and infrastructure risks. These have to be considered. And so on a practical end, for a lawyer, this is a roadmap you can follow when you're advising your clients. So number one, map out the business model and trade flow. And these are the various things to consider: what the product or service is. Is it a digital good, an e-commerce good, or an online service? Once you've established that, establish where it is supplied. Is it to Uganda or abroad, and to whom? Is it within the ESC or within the AFCFTA? So, and when you establish where it is supplied, then you're able to establish the legal framework that applies. Then you need to establish the jurisdiction in terms of the laws. I talked about that earlier. Then you need to also identify how payments are effected and how delivery or completion of the service is going to be effected. And then the other part would be which other regulatory regimes apply. These might include data protection, IP, or e-commerce. So those ones have to be considered because they go hand in hand with digital trade. Then on the regulatory and legal due diligence, the expected due diligence framework would be to review the national laws in each jurisdiction, and then assess the regional and continental legal frameworks that may affect businesses, and lastly, assess contract enforceability, mutual recognition of laws, and cross-border dispute resolutions. On the operational end, as a lawyer, you can decide whether to set up a local entity or a subsidiary or a representative. You can craft terms of service or agreements that are compliant with multiple jurisdictions. When you're dealing with cross-border digital trade, you want to be compliant to as many jurisdictions as possible. So what I would advise is probably look at if you're looking at the African region, look at the AFCFTA as a guide. And then when you're drafting, considerations for drafting contracts, you need to have digital contracts that have e-signature capabilities, data processing agreements, cross-border transfer considerations, payment service agreements and risk disclaimers, service level agreements, and incident response protocols, and cross-border tax or VAT clauses, digital service tax clauses that relate to the regions you're dealing with. Because if you're drafting a contract for cross-border digital trade, you need to consider the tax regimes and ensure that that is covered within the contract. Then on the compliance end, you need to put in place internal mechanisms and compliance policies, data protection policies, cybersecurity policies, internal audit for payment operations, and consumer compliant resolution mechanisms. And I know you've seen some of these apps like Jumia, they have those mechanisms already in place. You know where to go to raise your complaint. So all these have to be considered. You need to monitor regulatory changes in each jurisdiction. When we talk about digital trade, this is an area that keeps changing. So that means you need to keep monitoring the regulatory changes in each jurisdiction and or at a regional level. Then provide awareness or training to your clients if they are exposed to some regulatory risks. And also you can consider insurance for such risks, such as cyber insurance and data breach costs. When it comes to risk mitigation and exit strategy, key risks in cross-border trade operations include data breaches, payment fraud, non-compliance with regulation, currency or foreign exchange fluctuations, infrastructure disruptions, and tax audit exposures. So contracts should include protections such as limitation of liability, indemnities, jurisdiction and choice of law clauses, and force majeure clauses. Businesses must also plan for termination or exit, addressing the handling of residual customers, data deletion, and transfer obligation. So we need to maintain a clear evidence of compliance. So some of the things you need to maintain as advice and advising your clients is to maintain clear audit trails, logs, user consents, and KYC records to ensure accountability and legal protection for their digital businesses. So I'm going to move to, as I conclude, I'm going to move to future developments and what lawyers should watch. I already talked about the AFCFTA protocol on digital trade, which is fully implemented. We need to align our national laws with regional laws. That's one of the things that we need to do. We need to ensure that there is the interoperability of the different various digital frameworks within countries. So the growing use of interoperable digital identity system will require lawyers to understand cross-border KYC and verification processes. Then there are emerging technologies such as AI, blockchain, which bring new challenges to digital trade. And I believe lawyers, we should also look into that. The earlier speakers spoke briefly about that, and we need to tap in and advise our clients efficiently. So I have talked about the checklists and the things to look out, and these are e-signatures, data protection, payment and licensing, taxation, consumer protection, IP, cybersecurity and compliance, monitoring. Then I also talked about the exit strategy, to plan for data deletion in case of any risk and transfer duties and closure of cross-border customer relationships. All that needs to be planned in case of being exposed to risks that you cannot avert. Then, so as my closing remarks in terms of recommendations is digital trade offers very many opportunities for lawyers, but also brings up regulatory challenges. And these challenges are because you have to look at so many laws, and yet most of these laws are not yet interoperable. So that becomes challenging for a lawyer. But however, because there are so many developments that are happening in the region and in the continent, there is need for expertise and for continuous learning and keeping abreast with the developments that are happening at a regional level. And So while we have the ESC and the AFCFTA framework that harmonize digital trade rules, implementation is still uneven, again, because some of the countries have not adopted the laws yet. So you'll find that Uganda and Kenya are doing well, but then when you go to South Sudan, on the other hand, Burundi, you find gaps. So at a regional level, we are still uneven. But what I encourage lawyers is to stay informed, ensure compliance in structuring your transactions and your contracts, and help clients navigate the risks and capitalize on the emerging opportunities, especially the opportunities under the AFCFTA. Yes, that's all. Thank you.
Wow, Mabel, thank you very much for that. I hope there's well, I think we also have virtual emojis for those that are attending online. Please clap. You should give us those clap emojis. I think this is the point where we'll ask a few questions. Hopefully we'll have a few questions from those that are listening. Thank you very much for those that have clapped. Maybe as you can see, people have enjoyed. They've given you Wogalo online. But for those that are interacting with this topic for the first time, it may be a bit difficult to take in or assimilate all of this information. Now, the first question I want to ask you, Mabel, did you learn all of these things from Georgetown? Or how can a lawyer who may not have the same opportunity to be able to go to an Ivy League uni or to even extend the knowledge they've gotten beyond their LLB course or beyond their diploma in legal practice? How did you get into this field, Mabel?
Oh, how did I get into this field? Number one, I was passionate about it. I've always wanted a practice that changes lives. And when I started out as a lawyer, I realized, this is my personal opinion, I realized that when you're dealing with a woman, for example, who is undergoing domestic violence, I had a client once who was undergoing domestic violence, and it was the extreme kind of domestic violence. I remember advising that client and telling that client that you need to leave. For your life, you need to leave. And then the client told me, if I leave, I will die anyway because I don't know where to go. And then that occurred to me that economic development, us ensuring that there is poverty reduction, is key to solving so many problems that different people suffer. So, and that got me thinking, how do I support people become, how do I help people become better? And that is when I got interested in trade law in general, in commerce in general. How do I support people and help them become better? And with trade is about economic development. Because if everyone is allowed to trade or deal in something, they are able to make some money for themselves, and they are able to make better decisions and or take their children to better schools or enable their children have an education. So with that kind of passion, I was led to apply for masters. I was lucky. I applied in one university and I got in. I got a scholarship, and from then it has never been the same. And I was very lucky that immediately after school or during school, I got into the World Bank as a consultant, and for me that I learned a lot about economic development when I was in the bank, and the need to actually advance policies that enable businesses grow and become better, or enable households grow. If you're looking at the microeconomic level, enable households grow so that they can essentially be able to support themselves, support their children, and if we are able to do that at a microeconomic level, then you can achieve the economic development that we want. And that's why the AFCFTA is a very important document. Why? because Africa has, I think, the most countries. We have the biggest population. We have the consumer base. I mean, that's why China is here, because we have the consumers. China does not have the consumers for their products, but we have a huge consumer base. So if all of us went into trade, we already have the market. So all we need to do is work on the infrastructure, ensure that if you make your goods in Uganda, you can be able to sell them anywhere in the world. And with digital trade, you don't need to be a large company. All you have to do is sell where you're at. You're able to put your goods online. I've talked to you, I've shared about the ATEX. You can share these goods online, and you can let the buyers find you. So it's a good cause, and yeah, it's fulfilling.
So I am still in the...
For the lawyer out there. So for the lawyer out there, you can number one, pursue education, but then also a lot has been developed under the AFCFTA. They've been very intentional on putting down, bringing out courses that can help anyone, even a business person, navigate trade in general. So when you go to the International Trade Center website, for example, you'll find so many free courses that you can do relating to digital trade, women in trade, trade in services, trade in goods. So there are so many courses that are being handed down that are free, because I may tell you to apply for a master's and you don't get a scholarship, or you don't have the finances to do that. But there are so many online courses that are being developed. The Afrexim Bank has a course on the trade, intra-African trade. You can also try that one out. It's free, and it can help you navigate everything from standards, from business penetration to payments to trade financing, among others.
So, Mebo, what you're saying, in essence, is that for you to be able to get information, or for you to specialize in this area, either you study with it, and I first want to ask you a very quick question on that, actually. Could you have afforded to study that course had you not gotten a scholarship?
No.
Now, I know that for many advocates, that is an issue. You're thinking, can I afford to be able to go and study, get a master's degree, or do what? And some of the speakers that we have here, other than Mebo as well, we also have Mr. Joel Vasoga, who share a lot online about how you can get scholarships, how you can be able to expand. And I think the biggest issue we've had as ULS are the stories we tell ourselves, because we don't have means, or because we're practicing law in whatever chambers you may be practicing from. It is difficult for you to expand your mind, to tell yourself that, look, I also can be like Mebo Tsaka, I can be able to get this scholarship, I can be like Joel Vasoga and get this scholarship. What we are reminding advocates is that it is possible for anyone who is intentional about that to be able to do that. Second is something that is key. Of course, we know that as the Radical New Bar, we talk about democratization, and we are seeing that information has also been democratized. So even if you cannot afford to study, or even if you do not get these scholarships, even if you don't have that guidance, but we're saying this information is available, you have to look for it. On the other hand, now, through the Africa Continental Free Trade Area, through the East African Community, you have all of these short courses that you can do and information available to be able to skill lawyers in that regard. But you also mentioned something important about the role of policy and why you got into this field. I also have conducted a research looking at data-driven lending. For those of you that have borrowed money, let's say from MTN or from any of these entities, that has been a game changer when it comes to what we call financial inclusion. Because in our communities, for example, women are not allowed in certain cultures to own property. And so that means if you're going into the traditional financing system where banks take land as collateral, we're seeing that now women and other disadvantaged communities or segments of our population can access finance that can then be able to invest in their businesses. Now, as Uganda Law Society, as lawyers, do we have a role to play in ensuring that we have in an enabling policy environment that allows these technologies or these innovations to be able to succeed?
Yes, of course. Yeah, so as lawyers, we have a huge role. And if you can remember when I was talking about consumer protection, I called upon lawyers to advocate for consumer protection laws within the country. Why? Because I feel like we are the authors or mothers of policy. Yeah, and that is our primary role, I think. Before everything else, we need to ensure that the law exists. Because then if the law exists, then we have a job. But then if the law does not exist, if the law wasn't there, we all wouldn't have jobs, right? So we need to advocate for policies that support our people. We need to advocate for policies that support our clients, but also support the nation general to be competitive. And our role does not stop at advocating. Our role does not stop at advocating. Our role, in addition to advocating, we need to take action. We need to take action. As I think, as lawyers, we can create a bill and convince a member of parliament to present it as a private member's bill. We can take it a step further. We can take it a step further in addition to advocacy.
Okay, so with that also, maybe what I hear is that as a body of lawyers, as Uganda Law Society, we have all of these stakeholders. You have the judiciary, but then you also have this entire field where you have all of these other stakeholders that may not only give opportunities to lawyers, but where we also have a role to play as advocates in society. That question of policy. Do you agree or not that perhaps that also extends to what the rule of law means? Is the rule of law only related to governance as we understand it, or does it also relate to things like policy enhancement, things like extending opportunities and making sure that we operate in a country where, as lawyers, we have a meaningful role to play in society?
Of course. The rule of law extends to everything. And that goes back to my my example that I gave earlier of the woman who was domestically violated. If you deal with the rule of law in one aspect, probably to end torture, for example, and you don't consider the other aspects, then you may not achieve your goal. So I think it's an all-round issue, and all aspects have to be considered. All aspects have to be considered. So you're right in what you say, Ken. The rule of law is not about human rights alone. It is, but even economic rights are human rights, actually. They are actually human rights. Economic rights should be human rights, because if you don't have food, for example, what right do you have if you can't eat, if you can't drink, if you can't take your child to school? So even economic rights are actually essential. And all these other policies feed into that. Yeah.
So I have just one more question, but before that, I just want to contextualize your discussion. Again, for the lawyers and advocates that are attending this discussion, Mabel Chisaka is a woman, Mabel Chisaka is a mother, Mabel Chisaka is a wife. And beyond that, with all her qualifications, it may seem very easy for you to see a divide between her and you, maybe you may not have the same accomplishments. But overall, she is still a person like you. She's an advocate who has done 4 years of law school, done 1 year of LDC. And I think the difference is always the intention that you put in. And she has also showed you the different areas that you can be able to specialize in. We have seen that on that entire area of digital trade, you can be able to look at data protection alone, you can be able to look at cybersecurity alone, you can be able to look at tax alone, can be able to look at intellectual property alone, you can be able to look at East African community harmonization alone, you can be able to look at contracting within digital trade alone. I think I can go on and on, seeing that you just have to open your eyes and be intentional about that. So I want you to end with this. How do you balance all of these things and also come here and speak on the panel when maybe you had to make sure that your kids go to school? What encouragement can you give a lawyer to be able to further their career and have these hopes and dreams and aspirations to operate on a global level, World Bank, all of these things, but while also being a full human being that also is focused on family or focused on all of these other areas of our lives that make us a full human being?
I think by the grace of God. God gives me the grace, and having a supportive system around you. I think it's very important to have that. For me, I have, number one, I think first and foremost, I have an amazing husband. When I can't pick the kids, he's available. When my job, I travel a lot. This year, I think, I don't know how many countries I've been to. I can't even count. But having that person to step in the gap when, and relatives and friends who step in the gap when you're not there is very key. It's really, really very key. So, and then it helps you balance. You don't have to worry, have my children eaten? You know the best person is there watching over them. So having a supportive system, then even in the profession, having good people to collaborate with in the profession. Because like Ken has shared, digital trade has so many aspects. It has data protection, it has IP, it has tax. I'm not an expert at all these things. I know trade, but I'm not an expert at all these things. And Ken, we've done things together with Ken. I've done things with so many other lawyers. And my principle is, if I have a project and it has aspects of certain parts of the law that I'm not good at, I will collaborate with someone. So even with the trade policy, for example, I'm doing the national trade policy, the national trade policy development and implementation plan, and the national export development strategy for Uganda. But I'm not doing it alone. There are aspects of economics that I need to work with, and we have an economist on board. So I have another trade expert on board. So it's this work is not work you can do by yourself. Okay, if you want to do it by yourself, you'll break down. But there's need for synergies, there's need for collaboration, and you don't need to be a know-it-all person. You can work with people, and when you work with people, or when you work with different ideas, you always produce much better work. So that's what I can say.
Wow. Mabel, thank you very much. We can have just one more round of applause, and online as well. Mabel, thank you very much for your time. And again, really, I encourage for the lawyers who are watching, even in the audience, I'm seeing we have Raymond from the Dear Young Lawyer series. Terry Kauma will be here breaking down and demystifying some of these things. Really, what we're trying to do as Uganda Law Society at the moment, as a radical new bar, is to be able to democratize the practice of law, so that we can break it down and show you that these perceptions you have about big law firms, about practice, they are all perceptions. We as lawyers can all get where we want to go if we're intentional, if we are serious, and if we have people like Mabel who can come and talk to us, teach us, and make themselves available to be able to share this knowledge. So all the other speakers that are coming on board are going to really demystify this thing that we call practice of law, to encourage you, the young lawyers who are saying we don't have opportunities, we don't have jobs. Now, Mr. Raymond, when you're hosting people, host people like Mabel so that they're able to share their experiences and stories. I think what we lack as Uganda Law Society is we need to have more people share or share with us the experiences and help us to create the stories that help us to succeed. The stories we tell ourselves are ones of defeat because of everything that's happening in the country, in our society, and that I feel has to change based on your mindset and how you see yourself. So we need to start seeing ourselves as advocates, as leader that have a role in our society. And we're here, we're seeing that you can be a leader who is focused on policy work and digital trade. So let me hand back over to the team. I think we can take another 4 minutes or 5 minutes. I think Akankwasa is coming back to be able to have who is next? Louis or Joel? I'm seeing Louis and Joel fighting, so I think in our profession, it is who is senior to the other, who is going to take precedence. So let's take a short break, and then we'll come back and either have Louis or Joel. We'll see who has won that battle. Thank you very much, Mabel.
Right. All right. Welcome back from the short break and from the last discussion that we had with Mabel and the rest of the team. Thank you so much. So we've been talking about digital transformation and how it's just generally reshaping the sector, yeah? And in my opinion, this also goes to the finance and financial sector as well. And we are seeing a lot of digital currencies, cryptocurrencies, and things like that. So based on my understanding, when you look at, for example, the Foreign Exchange Act, its definition of foreign currency, and the fact that it includes electronic units that are accepted in other states, and how you see how El Salvador already, for example, uses cryptocurrencies and stuff like that, and has adopted the use of this. So as we're going into this discussion, I just wanted to pick your mind on that, and also find a way of us explaining that use and the implications in our legal practice moving forward. Yeah, let's get into it. So the person that's going to take us through this discussion is a friend of mine, Luis Chizito. And just a brief introduction, Luis is a commercial lawyer with specialist knowledge in legal practice areas such as international trade, capital markets, venture capital, taxation, structured financing, fintech payment systems, legal compliance, land transaction, data protection, banking. He has everything, yeah? He advises Web 3.0 based technology businesses on legal compliance requirements for virtual assets and asset tokenization in East Africa. Luis is a lawyer at Pentagon Advocates. He has advised Honorable Nabeta Igema Nathan on the private members bill tabled in Parliament that seeks to amend Capital Markets Authority Act to reform the capital markets and introduce regulation of virtual assets. He recently, in March, represented ULS's position and views on the Mortgage Refinance Institutions Bill 2025 to Parliamentary Committee of Finance Planning and Economic Development. That's very heavy, and clearly, yeah, it's very heavy. And this just makes this discussion a little more interesting considering the CV. So let's get let's get into it. Take the floor.
All right. I hope I'm not so loud. And I hope the listeners there can also hear me well. Okay, my presentation, you asked a few questions, but I'm going to cover them in my preliminary of the presentation. I don't know if the presentation is up, but you'll put it up briefly. I'm just doing some few preliminaries here. Now, Now, you should understand that I'm not going to talk about cryptocurrencies as we know them. I'm going to begin with the preliminary conceptual elements on where the web has been, where it is, at least before I go into the presentation, and where the internet or the web is going. Now, the cryptocurrencies fall under the wider spectrum of what we call Web 3. Web 3 technologies. We are going to go into all these things with time in the presentation. I felt I should lay this groundwork so that people don't, we are demystifying things here. Now, Web 3, and let me explain what the internet has been. In the early when Tim Berners-Lee founded the World Wide Web, he did not conceptualize that it would metamorphosize into what we are seeing today. So initially in the 1990s, you had Web 1, which was a read-only HTML kind of thing. Now, what makes Facebook is the introduction of Web 2, which created an interactivity to the internet, where you could post videos, JavaScript, and that you write back, share. What the Web 2 did not accomplish is ownership of assets. Now, that's where the cryptocurrencies fall into the Web 3, because they personalize the web, and then you can actually own assets on it. And that is why the Law Reform Commission of the UK, some of you have gone to the UK, you should have seen that the UK Reform Commission actually has proposed a third category of how to view a third category of property. Because what we know and what we have been studying in law school, at least from a theoretical angle, is we know choices in action and choices in possession. But the Law Reform Commission tabled a recommended law reform in the UK, and the bill is actually before the House of Commons to create a third category of data of property rights called the data object, which shows how Web3 has evolved to help people actually own assets. I'll give you an example of an email. What Web3 does and the blockchain technologies do, people should know that blockchain and digital ledger technologies are different things, but blockchain is a way of implementing digital ledger technologies, DLT. But what it does is that it helps you own assets on the internet. And I was giving an example of an email. The email, if you are to use the example of the email and how blockchain actually makes Web3 help us own assets, is when I send an email to you, that email, I cannot simultaneously extinguish it for myself. I'll have it and you will have it. What Web3 does is that it extinguishes my side of the email and then makes you have that email. So it's a double spend problem that has been solved by the Web3. That's where lawyers and lawyering is important in Web3, because we're going to be discussing property ownership. How is it settled in the capital markets? How are these stablecoins we're going to look at? How are they tokenized? And because the contracts I've actually dealt with, and this is my last introduction before I go into this presentation. I've done 2 tokenization projects. I cannot mention them for Mr. Mohanji here, might get the client being senior, but they are actually, this is not a theoretical undertaking. We're not trying to do some academic discussion. These tokenization projects are there, and like we're going to see in a presentation, because we're a natural resource rich country, tokenization of gold is happening. Actually, in the Ascente group is doing it in, this is public, I can say it, in Karamoja. This is another tokenization project. So it's a way of creating a secondary market. So, and lawyers are very important in this exercise. That's why we are demystifying things here, broadening our horizons so that we can create new opportunities. And basically, so it's not an academic discussion, it's a very real discussion. Yeah. So can I go to the presentation? All right, having brought that out, taken that out of the way, we can. Okay, now most of us know the World Bank president. That gentleman is the former CEO of MasterCard. MasterCard, yes, MasterCard. I extracted that quote from, if you see the image there, that recently we have been having World Bank IMF meetings, and that's why he was having a session with the IMF director and I think the other participants. That quote goes to show how the idea of, remember we're going to discuss stablecoins, and stablecoins fall into the wider spectrum of cryptocurrencies. But I'm going to explain it briefly. But a stablecoin, if you've been following the Genius Act in the US, MiCA, Kenya now has a virtual assets law. 7 African countries have laws on this kind of things. Uganda is a work in progress. We're going to get there. So that gentleman and that quote shows that stablecoins are actually going to lower the cost of remittances and payments and money transfer cross-border. There are technicalities to that, but that is the bottom line. There are some stablecoins that are going to be more expensive, but the bottom line is they will. Now, that quote, if you want the detail of it, you should go to the YouTube page of the IMF, and you'll actually see the entire session. So that goes to show, I'm just setting the ground here. So that's the quote. And that gentleman, being the former CEO of MasterCard, knows exactly what actually he's saying, because he's coming from really a market experience point of view. So what kind of lawyer is this training for? It's important that I actually set the stage for this. If you are into cross-border transaction where you have a lot of parties and counterparties, stablecoins are going to help you in that, we get our money through rails. A rail, I will describe it briefly. A rail is how money comes to you and me. Mobile money, payment instruments like card, though cards are not very popular here, bank, EFTs, we have RTGS, Bank of Uganda settlement systems. So those are all rails. But if you are into contracts where you're dealing with a counterpart in the UK, a party in Kenya and Tanzania, where you want lower costs, we are increasingly seeing stable coins as forms, especially the USDT, as forms of consideration. So that will be important. If you're into mining and resources, I've talked about tokenization. So this debate is also very important. Discussion is very important for you. If you're a company secretary and you're into risk management, financial sector, certainly, financial intelligence, academia, and also, really, if you're into fintech and compliance advisory, this discussion is really for you. Then what are rails? In Uganda, we basically have rails that go through majorly 3 categories of people. We have the central bank rails. I've said the rails are how money comes to you. We shall discuss the singleness of money later, but that is how money comes to you. Now, the central bank has its rails, and those are RTGS systems where they use central bank reserves to settle payments. And that RTGS system normally has, I think, 27 banks. Yes, it's not open to the public. So we also have bank rails. Some banks can issue cards, other banks can also issue all other rails. So that's how money comes to us. And non-bank, like the fintechs, mobile money, all other emerging. Now lately we have the stable coins. So all these are rails. That's how money comes to you. The infrastructure, the underlying infrastructure that we don't see that transmits money to us. So there's a problem. I didn't want to go into the presentation before I dispel a few problems. I'm sorry for people at the central bank. We have been having a few issues with that image. That image basically shows the rails, but because we are discussing tokenization and stable coins, it's important that we understand how assets are held, both in the financial sector and rather in the capital markets and the banking sector. Now, when you to your left, you'll see the blue column. It has what you call the rails, which are, there is a security central depository there which holds government bonds. Now that ideally is not a payment system, but under our laws, the National Payment Systems Act, it's seen as a money transmission system. It's a custody system. We have been debating with them, and I felt that we should correct that to understand, especially if you're in the central bank, that if you're going to tokenize, we should first of all understand how our assets already held, so that you tokenize right. Tokenization is the idea of bringing things on the blockchain. So the problem with it is that we are mixing up what is holding people's assets in terms of bonds and then what is transmitting money. So it's important that we actually get that out of the way. I thought I had to put that slide there just in case. So what's new? These are 20 slides, but I'm going to rush through them very fast, and we shall go to the most important things. Oh no. I don't know what's wrong with that page per se. I don't know if, I think, okay, let's I think it's my, oh, okay, certainly. So what is new? You know, if you look at the idea of tokenization and bringing things on the blockchain, and we're going to go into the conceptual definitions later, is that what blockchain-based money rails do is that they give you what they call free ledgering. You do not necessarily have to reconcile payments after some time. Actually, I'm going to give an example of JP Morgan. JP Morgan is one of those banks in the world that actually does a lot of money transmissions. But they settle and reconcile those payments every month. So it's a nightmare. What blockchain does, and once you bring something on chain, is that it gives you a simultaneous value of money or store of value, and then ledgering. So you don't have to, it's finality in itself because the way the information flows on those ledgers. So if you're going to tokenize something on it, if you're going to tokenize something on a distributed ledger, it goes through that. You have an asset, then digital asset, and then a digital code token. So there's already an asset that's underlying. So you're just bringing it on chain. So that image, for our viewers who are online, sure you can see it very clearly, is that you only create a digital asset once you put it on the blockchain. And given how the information flows on the blockchain simultaneously, you actually not only get the money, the value, the store of value itself, but you also get that transmission. So this is something revolutionary. Because if you are going to develop an app, like a banking app, you have to develop a completely different process for settlement and reconciliation. Actually, mobile money companies do reconciliation of the equivalent of the electronic money issued with the money they have in a bank each and every day. So with blockchain, you don't have to do that reconciliation. So that actually lowers the costs if it is designed right. So what is tokenization and how does it create stable coins? But I think my slides were mixed up a bit here. But okay, I think I've been to that. No, types of stable coins. I hope I've got the conceptual ideas out of the way. I hope we're on the same page. I hope so. So the types of stable coins, we have what they call fully collateralized custodial model, and then the algorithmic partially collateralized model. Though the Genius Act and the MiCA and the Hong Kong and Singapore legislation outlaw the algorithmic, and I'll explain it later. They are more in favor of the fully backed. A stablecoin, for instance, if you are going to deposit $1, you should issue an equivalent token of that dollar, and it should be redeemed at par. So there's a 1-to-1 backing. For every dollar that is kept, there's a token represents that dollar. So it's 1-to-1 backing. And if you are to redeem it, you should redeem $1 of that token. So it is basically the two types. If the other blue slide goes into the detail, but broadly those are the two categories. Now, in the fully collateralized model, we have USDT, which is owned by Tether, and Circle's USDC. Especially in the contracts you're going to design for your clients, you will actually see majorly those two stable coins because they are fully backed, and with the coming in force of the Genius Act and the geopolitical developments elsewhere, Ugandan lawyers are likely to see those forms of stable coins. The algorithmic are actually not fully backed, but they depend on the algorithm. Basically, how can I explain it? They are backed not by real money, but by some sort of underlying asset, which is not a physical asset, but it can easily also be redeemed for dollars. So it's not a 1-to-1 backing for an algorithmic. That's why you'll see the Terra USD, the ones that collapsed, Terra Luna's fiasco around 2022, 2023. But I wouldn't encourage a lawyer to advise a client to settle a contract in an algorithmic stablecoin. Yes, from my personal experience. I could be wrong. So the legal mechanics for stablecoin issuers. This is the standard global practice. We don't have a law yet, but that is the standard really. If you look at, I've summarized what all the laws were saying, what the Hong Kong law is saying, what the Genius Act is now saying, because now it's now a law, what MiCA is saying. So there's a reserve requirement, a 1-to-1 ratio. For every dollar in a bank, there should be an equivalent of a stable. I've already said that, but how do they do it? For instance, if you look at USDT, which is owned by Tether, USDT actually invests in short-term treasury instruments, which are treasury bonds. Why? They don't want to expose themselves to long-duration assets like the bonds that are above 1 year, because they come with the market risk, where inflation can really tamper with the value of the yield. And that yield is not supposed to be paid to you, the holder of the stablecoin. Stablecoins are non-yielding assets. In other words, if you own it, I'm not supposed to pay you money like another asset. So for its purposes, it's a fully backed asset that is an instrument. So what Tether does, actually, the biggest owners of non-sovereign owners of US Treasury bonds right now is actually stablecoins, Tether and USDC, to the tune of, I think, $150 billion. And the number is exponentially rising. So that backing, they back through owning real assets. And that yield is actually paid to the stablecoin issuer, Tether. It's not supposed to be given to you. Unlike the mobile money, when you look at our National Payment Systems Act, if you have money on your account for over, I think, an average of 90 days, there's that money that they hold in a bank somewhere generates interest, and they're supposed to distribute it to you, the customer. Stablecoins, the global practice now, if you look at MiCA and the Genius Act, they don't. It is 1-to-1 backing, and it's a non-yielding asset. Hope that's out of the way. Then clear redemption rules. When the CFTC and the SEC and the Office of the Future Control, even the EU, once they come up with rules, they already have the US, they'll come up with the rules, but the EU, they already have some rules, because I have some clients that are already using USDC. Redemption rules have to be clear in that if I am holding 50 USDT, I'm supposed to redeem 50 USDT. That is non-negotiable. Then fund segregation. The assets of the issuer, Tether, are not supposed to be intermingled with the assets of the people who actually own those stablecoins. So those accounts have to be segregated. The same way we have with, if you follow the collapse of FTX, the issue was there. Though FTX is a different example, but it kind of ties into it. Then prohibition of payment, which I've just explained that. Non-yielding assets. They are yielding stablecoins, but those are not supposed to be payment in stablecoins. Those ones are capital markets products. So then AML, KYC, actually already, virtual asset service providers in Uganda are supposed to file returns with Financial Intelligence Authority as accountable persons. So our Anti-Money Laundering Act actually already provides for it. But again, the global practice, that is basically the legal mechanics behind a stablecoin. So as a lawyer, if you ever find a contract which has a stablecoin where maybe there is some sort of agreement to settle in stablecoin, those are key features to look out for. Though my worry is we're going to sort of treaty jurisdiction shopping, where someone will issue a stablecoin in a country where there is no law or the laws are weak. So as a lawyer, it is your duty to find out which jurisdictions are trusted, which ones are not trusted. Because if you have to go to the Cayman Islands and they have issued a stablecoin in Cayman Islands, which is a tax haven, chances are high that client might not be as protected as a client who is going to be settled in stablecoins that are governed by laws of maybe British Virgin Islands, the US, EU, or even now Singapore. So you have to look out for those mechanics. They're very important. Benefits of stablecoins and what's different. I've just explained this. I'm not going to go into it. What I've just said earlier is the difference with stablecoins as a payment instrument is they give you a store of money value and a free ledgering process. You see? So it actually lowers the cost. Other rails have separate entities. They store money differently and then the ledgering is elsewhere. So implications for legal contracts. Now, I was looking through a token generation, rather, an independent contractor and independent contractor and token generation agreement, yes, where a client was settled in stablecoin and then an independently internally generated token. Some of the things to look out for, especially if a contract is dealing with stablecoin payment, is a token generation event and how it vests over time, whether it is fair and whether it is either governed by securities laws or it's not a security and it's a payment instrument. I hope I am not going overboard here. You know, we are breaking down things here today. I really hope so. So you look out for the compensation, how it is structured. Will it be partial stablecoins, fully stablecoins, or there will be a token generation event where some tokens will vest over time? You have to look out for gas fees. Now, gas fees, this is a little bit unique to stablecoins and tokens that are going to be where contracts are settled. A gas fee is, you know, there's something called validation on blockchain. You validate blocks. Now, the cost that comes with validating that block and validating transaction is what you call a gas fee. Now, a gas fee, it depends on the demand and supply of that token at the time. So those gas fees in contracts are normally supposed to be paid by the person who is going to pay you, not your client who is going to receive the money. If it is your client, then the one-to-one backing might be actually tampered with. Then it has to be a compatible wallet address. If it's an Ethereum block, my goodness, if I'm going very far, please tell me. Just put up your hand. Yeah? Okay, there are blockchains, and Ethereum is one of those blockchains where smart contracts are actually generated. Not every token has its what you call blockchain. So you'll find that now we have layer 1, layer 2 on blockchain technology, and it's that blockchain on which they're developing these smart contracts to give you the stablecoin. Now, if it is a wallet that is incompatible with that blockchain, it could be a problem. So it has to be maybe an Ethereum compatible. So again, the registration status is very important. Like I said, you have to look out for each jurisdiction. Token risks. Okay, I'll get into that later. Countries of interest with Web3 laws already. Web3 I've explained already how it came about. So those are the countries. I think those are the countries I would trust a bit. Though Dubai, okay, but but I would trust those countries. But they also have some good laws already. The US is yet passed the Genius Act this year, but in July, they're yet to come up with rules. So the Genius Act will come in force around 2027 when the Office of the Official Controller, the SEC, and the bank chartered regulators who really regulate the chartered banks in the US come up with those rules. So now let's get into my favorite part, which is the capital markets. I hope we have really set the stage for what I'm going to discuss. Now, it's important to note that in capital markets, assets are held differently from the normal payment rails. In the capital markets, we're dealing with something called, and if some of you have invested in unit trusts, you have seen that thing of assets under management everywhere. So in a bank, assets are held as liabilities on our balance sheets. For instance, the bank takes risks with that money. If you ever go into a bank statement and maybe the bank is issuing its maybe this year's financial statements in the newspapers, you'll see that deposits of customers are held as liabilities. Now, in the capital markets, there is something called assets under management. Those assets are held not on the manager's balance sheet, but on a balance sheet of someone else, and they are managed on your behalf. So if you're going to look for your assets on the balance sheet of stock exchange, they will not be there. On fund manager, so that's what they call assets under management. It shouldn't take so long. So I'll get that out of the way. Now, capital markets use cases, basically, those are, we have seen tokenization in investment grade bonds. We have seen it in real estate. We have seen it actually in cash. I said there are some stablecoins that are yielding. So you'll see some stablecoins that are settling capital markets transactions. I think DTCC, we shall get there. DTCC is a custody, and we're going to get into that. It's a custody. It's a custodian. It's a depository where the digital entries of what you have are kept. We have seen some tokenization use cases in the dematerialized securities, which are held in own depositories. We shall get into that through the presentation. Now, tokenization, like I said before, is bringing assets on the blockchain. And because of how information flows simultaneously, the information doesn't flow in a linear fashion. Now, asset servicing and life cycle of a security. I'll give an example. When you go for an IPO, MTN did an IPO. Airtel was the latest company with an IPO. That IPO is the first time the security is issued. Then after it is issued, you go into a listing. After a listing, you go into post-trade, secondary trade, and then you have what they call management of rights of investors or shareholders. Now, that life cycle of a security can easily be tokenized depending on the blockchain. And the information flow will not be as linear as you see there, but it will be, some of these things will be pre-agreed and then coded into the contract, and then it will flow. Their corporate actions like dividends, stock splits can actually be encoded into the smart contracts. And then they can leverage the immutability to actually provide you service. Where lawyers come in is there will be risk managers. We shall get into that. So some of the asset classes that have actually been brought onto the blockchain, you could actually see them there. But this is my concern. Illiquid assets. Good. If the terms illiquid, for instance, if a share is listed on the stock exchange and it can easily be traded, that's liquid, like bonds, liquid. Once a private company has shares and you want to sell them, I think lawyers know that that can be a little bit harder because you have to run around it. It can take months. That's what an illiquid asset is now. Blockchain makes illiquid assets, privately issued shares in companies, be brought on chain and settled in a much faster way, especially if you're raising capital. Now, we are seeing increasingly that things like syndicated loans, private equity, illiquid, you call them instruments like private equity. If they're brought on board, you can easily get create a secondary market for them, and you can dispose of them much faster. And one thing I should get out of the way is that dematerialization is not only for public companies. Actually, when you go to Uganda Securities Exchange, which is not very far from here, they can hold assets for private companies, their depositories. Actually, they do. Only that lawyers, we don't know about this, but we are demystifying and creating information today. If you have a client who maybe wants to raise some money and is already undergoing the process, Uganda Securities Exchange already has that service. They can actually hold for you those assets, and then they can actually bring them on chain using the records that have been dematerialization. Ladies and gentlemen, is not a Web3 concept. It is already in our capital markets. It is the physical elimination of physical share certificates. That's what it means, that are held on a depository. The practicalities are you surrender your physical share certificate, and then the securities exchange, its depository holds it, and then they issue you digital entries. Now, it's those digital entries, they open for you an account on which those shares are held. It is that they tokenize. I feel like I am breathing all the air out of the room. I just feel, and I am so saddened, really. It's like I'm sucking out all the air out of the room. As the presentation is not as fun as I thought it was going to be. Yeah? But fine. But fine. Now, I've talked about how assets are held in the capital markets. The issuer of the security, the seller of the security, does not do the safekeeping. That's the argument I've been having with the central bank. You issue your bonds and then you want to keep them with the central bank. The same aspect actually applies. Now, when they open for you, when you're going to buy government bonds, and they open for you an account to hold those bonds, that's a depository. Yeah? Now, that system is how they hold capital markets products. The issuer does not hold or own that depository. What is happening with BOE is a little bit of an anomaly, but they are rectifying it. Now, in the capital markets, we've been having what they call a current, an account-based model of holding our assets. You go to Uganda Securities Exchange, you go to Bank of Uganda to buy a bond, they open up for you an account on their depository, and that's how they hold your asset. What Web3, the Web3 and virtual assets, Web3 rather does, and blockchain DLTs, like I said, blockchains are an example of a DLT, but not all DLTs are blockchain. These are two different things, but the concept is largely the same. What blockchain does is that it creates what they call a wallet-based model of holding. You have held, some of us who have held cryptocurrencies before, you know that you're given a private key and a public key. You get? Now, if you're going to introduce that concept in the capital markets, first of all, our laws here in Uganda may not allow it, but it brings into other questions like, what is finality of settlement? Finality of settlement means you give me money, I give you the security. In technical terms, it's called delivery versus payment. You pay, I deliver. So on blockchain, you don't have, if the asset is brought on chain, then the account model still remains, but now you have a layer of a key, a private key where someone can send, where you can access your money, a private key, and then a public key where someone can send you the money. So a wallet is generated, and that within that wallet they generate for you private and private keys. Now, that brings around legal issues of, will the wallet best model replace the current model we have? Recently, the Australian Securities Exchange tried it at a cost of $100 million, and they were banned, which shows that if you're going to do such things, a lot of legal due diligence has to be done, because there's a sort of incompatibility, and what Mabel called interoperability issues. So that's where lawyers come in. Risk management, how are you going to manage the transition? And these things, they may not come in Uganda, but elsewhere in the world, they are coming. And if they're coming somewhere else in the world, just know at some point, we're going to deal with these things. And especially if you're going to tokenize now, like the gold projects that are ongoing in Karamoja, you will have the physical gold somewhere stored, and they will give you a receipt for it. Now, if you're going to create a token that where people are going to own an equivalent of that gold in a token form, generate for them wallets. Now, finality of settlement has to be discussed. Where is settlement done, and who holds the final sway over it? ETCC, I think the presentation is almost ending. Now, this is my last slide. I think second last or last, it should be one of the two. Now, I have explained about corporate actions, where lawyers come in now. A corporate action, an example of it is if you have paid your money and you have shares. Dividends are corporate action. Investor communications. If you have invested in government bonds, there is a coupon. That is now, I think the example I gave there is a coupon. How a coupon can be brought on chain from the traditional storage, from the traditional securities depository way of keeping assets. I adopted that from the Singapore Stock Exchange because they're very vigorous with that. Now, a coupon payment, for those of you who have bought government bonds, you know that coupon payments are every 6 months. Every 6 months. And then on top of doing that coupon payment, it is processed through what you call a depository. Because remember, I've told you a depository is one that holds your assets, independent of whoever has given them to you. Now, there's someone called a paying agent. A paying agent is the person who actually who informs the securities depository to pay that money, and then the paying agent tells the bank to execute that action. Now, that is the old. To your left, that's the old system. Now, to your right, that is something that people are proposing, that if we are to bring a digital custody mechanism, how are we going to solve corporate actions? Because remember, like I told you, in our current system, information flows in a linear fashion from one person to another. So there's also room for what you call information asymmetry. What then on your right, when you bring it on chain, what it does is that information flows simultaneously, because remember, on that ledger, each and every node has access to that information at the same time. And most of these coupon payments, like government bonds, are pre-agreed. So they can be coded into smart contracts, and then information travels not in a linear fashion, but simultaneously. So that solves information asymmetry. And we have seen examples where corporate actions have been brought on chain. For instance, when you look at DTCC is a custodian for government bonds. I'm using DTCC because even in Uganda here, we have an account with DTCC for purposes of our reserves to hold our government bonds. DTCC is a securities depository that handles some of the government bonds for sovereign countries. It is experimenting, actually already doing it. It is settling using stable coins through their platform to actually settle the securities that are on that platform. So that's the end. I'm shocked the presentation has been so short. Hopefully, I didn't want it to be so boring or so technical. If I've been overly technical, please forgive me. There is room for questions. But my idea today was actually to open your minds. These things are happening. Tokenization is real. Uganda being a natural resource hub, we're seeing a lot of these projects. So as a lawyer, you're going to be told to write a legal opinion on a token issuance. What are you going to do? So I felt that this area is not only emerging, but it is actually here, because the Ascenter group, if you Google the Ascenter, you will see that they're having Coin Market Cap, I think, wrote an article about the tokenization projects going on now up there. So if a lawyer is asked to write an opinion on whether this token is suitable for public consumption, those are some of the broad areas. You have to first of all know, is it a payment stablecoin or it's a yielding stablecoin, which is going to be a capital markets thing? Is it going to be tokenized as an asset that's going to call for the public to invest? So these things are here. They're not academic, and I hope I have broken it down. I didn't want to be technical. If I've been technical, forgive me, but at least I've opened up your minds. I'm sorry.
Okay. I think the best response right now would be, yeah, that it was heavy and very, very thick, but we do need to hear these conversations. And I think what I can ask is whether there's an opportunity for you to take time and teach, like take people through these step by step, because this is not traditional information that you're going to find in schools and stuff like that. So this is something that we need practice on as lawyers, because these are things that are going to come. So just to understand, we've understood how we've moved from Web 1 to Web 3 over time. And I think what my major concern is why we're not yet why we're not yet at Web 3, why Uganda is not a country part of the Web 3, and when are we getting like Web 4 at that point? But also, I've also understood that blockchain, stablecoin, tokenization, these are not replacing the traditional understanding of finance. It's just sort of re-engineering how we're going to deal with finance moving forward. And so our question as lawyers is just to understand how we can advise clients and make sure that we focus on understanding that Uganda is the one that's a bit behind. I don't want to say so behind, but we're a bit behind. And we're having so many clients coming in and asking for advice on such issues, and we do not have the right set of tools to answer these questions. So on my end, I just want to understand, how do you think the laws in Uganda are affecting businesses in Uganda? Yeah. So how are laws in Uganda generally affecting how businesses are operating due to maybe our failure to recognize other currencies and to properly operationalize use of the tokenization, the cryptocurrencies, the blockchain, and whatnot? How do you think that's affecting that? And how do we, and my earlier questions, how do we get Uganda to be part of those, of the Web3, the countries that have taken interest in the Web3 laws? Yes, that's that. And then this should be integrated in school syllabus. Yes, they should be. The idea of physical currencies tickled me. Please explain. From Henrietta. The question is the idea. Yeah, please explain with examples of how these work on physical securities. Yeah. I think those are the only questions. Yeah.
Okay. I'm going to start with your preliminary question before I go to the currency thing. Uganda is so behind. What should we do? You know, I don't want to say much about that bill that I drafted for Honorable Naveta, but we had challenges at the beginning because that bill had all these things we're talking about, but virtual assets. I think I shared it with Joel. I must have shared that bill with you. Initial Minister of Finance, they were opposed to it, as they didn't even want to hear the discussion. But what helped us, as we're explaining to them, the Genius Act was passing, British Virgin Islands was passing its law, Kenya was having a white paper, Mauritius had passed its law, and most of the tokens we're dealing with were in Mauritius. So right now, as I speak, the cabinet, the Financial Services Department, Mr. Ogwapos, the commissioner, reliably informed me, I think about a month ago, if not two, that they had finalized the cabinet white paper to actually bring the discussion to bring the discussion of virtual assets. Well, if we have been struggling with it here, they will struggle with it also, that cabinet, to bring the discussion to them. So I think the cabinet white paper is ready for a virtual assets bill. Whether there is enough lobby power to push it over the line and to get it out of cabinet to parliament is a whole issue. But we are getting there. And secondly, lawyers, how can we advise clients on this? You know, as a lawyer, you can't wait for a law. Because I'll give an example. People are tokenizing gold in Karamoja. Are we going to wait for a law? Because remember, that token might be tokenized Ugandan gold, but they're going to use Mauritius virtual assets laws to actually offer it to the rest of the world. You get? So I think you see how Uganda is losing out. You have your gold here, and the gold price is really going over the roof. And instead of using your own laws to tokenize that gold and create a secondary market for it, you're actually using Mauritius. Even Kenyan laws might take some time, but President Ruto signed their law last week. So as a lawyer, you cannot wait for a law to pass. You just have to understand the geopolitical trends and how they're evolving. So we are getting there. We are behind, but I think in the next 4 years, whether you want it or not, there will be a Ugandan virtual assets law. At this point, the resistance is not there because there's an agreement at Ministry of Finance, there's an agreement even at Bank of Uganda, even at Capital Markets Authority that we need this law. Actually, my joke has been that they're just going to copy and paste what the Kenyan law has and bring it here. That's what they always do. But so then the other question was, you had another question on the currency and.
No, I think my issue was on the laws and how the laws in Uganda are affecting the businesses generally.
Yeah. On that issue, how laws are affecting business. I'll give you an example. I'll give you an example. Right now that Kenya has passed its virtual assets law, and a friend in New York was telling me this over WhatsApp, I think last night as I was preparing for this. He told me now that Kenya has passed its law, there's going to be a huge rush into East Africa for tokenization projects. Not cryptocurrency, Bitcoin, because remember Bitcoin and cryptocurrency. Cryptocurrency is a broad category. Bitcoin is just a small component. It's an example of a cryptocurrency. But then you also have stable coins, also an example of cryptocurrency, but those are also different types. Now he's telling me blockchain projects, because of the legal science in Kenya, are going to be there, but they may end up spilling over to Uganda. Now, the lack of regulation means that we are putting ourselves in the rule of law of other countries. Because you see, blockchain, the problem with blockchain is that it is everywhere and nowhere at the same time. because a distributed ledger which has activities all over the world, people are validating transactions all over the world. As Uganda, you're not going to stop it. So you just have to jump on the train, and move. So the problem we have, and what lawyers are going to face now, like I'm talking about stable coins, increasingly you will have a contract that is governed by Ugandan law, but when it comes to the consideration and the mechanics of it, it may be governed by British Virgin Islands. And I've seen this. I was really designing some contract sometime, and I saw the contract is Ugandan, the form, the standard, but when it comes to the consideration and the form of it, it is governed by the laws of the British Virgin Islands, because that's where the laws that they're using to pay you up. So even when you may get a wallet that you're holding in Uganda, and in case maybe one of the conflicts that's going to happen, especially with stablecoins, and I should have gone into the disadvantages, the depegging. It's very possible that a stablecoin, much as it is 1-to-1, it might be depegged, and one token may represent 0.5 or 50 cents. So that depegging, in countries where the laws are not clear, you'll be putting yourself outside. So that's even taking business away from us, because now our courts are not going to arbitrate such. You go to British Virgin Islands, and any arbitration center, if you're going to go and instigate an action, is expensive, especially outside. Guys who have done arbitration, very expensive. So the lack of laws, I will answer your question briefly, and I say, one, it's taking business out of lawyers' pockets, and we are really struggling to put money in our pockets. Then two, we are putting the entire clientele outside of a rule of law they don't understand, because these things are not going to stop. Blockchain is everywhere and nowhere at the same time. So we need the law, and why the law is also impeding our development is projects are going to rush here, and once they rush here and find no law, they will have to look for what you call jurisdiction shopping. Because some countries are passed, other laws like the EU are strong, then other countries like, I don't want to mention them, are weak. So you find that a token is issued in this. Now, as a lawyer, it's your duty to find out all this. Now, the law not existing means that the customers are not protected adequately, or the investors. So without investor protection, without client protection, it means that increasingly we're going to see more what they call scams. And so for me, I'll answer your question briefly and say, lack of laws is putting us into the arms of other jurisdictions, because as Uganda, you're just not going to ban these things. Because like I've told you, blockchain is everywhere and nowhere at the same time. So you just have to regulate the damn thing. That's what I would say. So I don't know if I've answered your question clearly,
Yes,
or gone overboard.
No, you've answered it properly.
Then there's a question on the currency recognition and.
No, I think the other one was on the physical securities.
Now he was asking how physical securities.
Examples of how physical securities work.
How they work without the blockchain element.
I think at this point, just
okay. Physical securities. Let me explain it first. If you're going to list shares on a stock exchange, or you have invested in shares in a stock exchange, you're not going to ask for a physical share certificate. The rules of the stock exchanges and the depositories don't allow that anymore. For instance, if you are going to invest in MTN IPO, you're not going to run to MTN and you ask them for a physical share certificate. Right now we have something called a Securities Central Depository Act. That act says that just because I don't have a physical share certificate does not nullify my ability to say I own something. Right now what is done is that they open up an account for you, and those digital entries and the number of shares on digital entries are by themselves final, and they suffice for a physical share certificate. So they are final and conclusive. Now that is, I don't know, a physical share certificate, you don't need it. When it comes to our private companies, of course, if I am going to register a company, I'll have share capital, and from which I will divide all the shares and create, where possible, share certificates. Now, those share certificates, you can keep them, but what I was explaining earlier was those are illiquid instruments. In that illiquid, I mean you cannot exchange them for money immediately, like the way the traded shares we have. Now, if you're going to tokenize a physical share certificate, it becomes complicated because the record on which it is paper-based. It becomes easier once those shares, for instance, I've just told you that the Securities Central Depository Law does not only proscribe dematerialization, elimination of physical shares to publicly listed companies. Even private companies, in my view, if you have more than 100 shareholders and you are in VC cycle, like my friend Luvama is as a VC guy, and you want to create trust for that record, if it is a dematerialized record, it is easier. Because especially if you're dealing with around 100 shareholders. Remember, you're a private company if you don't have more than 100 people, right? If they're less than 100, that's now private. Now, if there are many and you're into this cycle of raising money all the time, it becomes easier to dematerialize that record and even tokenize it now. How do you deal with physical securities? That question is vague, but I've answered it in, okay, I am not trying to say that the person who asked it is not right, asking it right, but what I'm trying to explain is how they work, especially in the blockchain Web3 space, depends on how they are held. If they're privately held, you can tokenize them, bring them on chain, though it will be problematic. But if there is a record somewhere, especially if you have 100, I'm talking about a company that has 70 to 80 shareholders that is redeeming all the time. And especially you're dealing with cross-border clients. If that record is held for you by a deposit, how it works in practice, if you're going to dematerialize a security of a private company, is that you hand over the share certificates. Then there's the big jumbo certificate first, then the small ones to the securities exchange. It holds it for you. Then they will issue for you an equivalent of the value of the shares or the share certificates you want in digital entry. So that's why they call dematerialization. In Web3, dematerialized securities can also be brought on chain, but that's a whole different layer. Now, the question that will arise there is, where does the finality of settlement occur? If I am creating a tokenized share or a bond that is held on a depository, and I am creating another layer of a wallet-based model, settlement means in capital markets and depositories, we have a language called delivery versus payment, DVP. You pay and then you deliver. That's settlement. So settlement is determined at point of payment. Now, if it is payment, should it be done on the tokenized asset or on the underlying asset where the security is held on the depository? So those are the legal questions that we have to ask. How it works in practice, it's a work in progress. I only know of one jurisdiction that has actually done it successfully, where they create security tokens and trading, and then there's all that layer. But that's why legal clarity is important, because under our laws, share, especially for choices in action, for shares and all that stuff, ownership is only defined by two laws. That's the Companies Act and the Securities Central Depository Law. If you have to create another layer of wallet-based model, does it suffice? Because remember, I told you about the UK Law Reform Commission and data object. We don't yet recognize that deeply, though it will come. So how it works, I hope I've answered your question very clearly, though I have been all over the place, but it was intentional for me to be so that at least you get a general picture. So basically, that's how it works. Hopefully, I've answered the question. But guys, forgive me if this discussion has been overly boring, overly technical, but these things are really happening. The other day, I had a client who told me, Louis, I want to tokenize something, but you come and do it for free. I was like, Louis, my goodness, how am I going to survive if I'm doing something for free? So tell the client I also exist. So instead of calling Louis, at least get an idea and Louis can be an afterthought maybe. So hopefully, but is there another question? I hope.
No, I think that was the question. I just want to appreciate you for taking us through this. Louis, how out of the technical, how have you gotten here and how do the lawyers get there? In terms of understanding, going down to understand this kind of information, because since it's not generally out there, how do we get there? Because this is one person that knows this information.
Is it really?
Well,
I know there are a few lawyers, but they really exist.
Well, right now we're talking, and I'm saying that you're one person, and there are probably 5, 6 out there. Yes, but unlike how we go to law school and law development center, and we're taught the basic law, how do we get to have this information? Because it's not just 1, 2, 3 people that should be knowing this.
Yeah, that's true. Yeah. But it also works for me. Very few lawyers know it because everyone comes to me. And they will not be going to H&G to actually disturb Joel here. So, okay, but for me, how I got there and how someone can get there. Number one, in the information age, when I was, actually, I don't want to mention the firm, but for me, my head start came when I was at 2017, 2018, final year law school, and I was looking for a place to go and intern. As a young lawyer, I started from a law firm that had a partner who had just done all these things at Berkeley, UCL Berkeley. I hope he's not online. If he's online, I know you can recognize. But I know people know anyway. So that Berkeley gentleman, at that time he had time. And I don't want to mention him because I'm sure he's going to call me out for even this vague example I've given. So that gentleman, he had the time. And, we had, as young lawyers, we have this thing that senior lawyers don't have time for us. But I would thank that gentleman, he had time. So he gave me a head start. As a young lawyer, I think someone can look for, one, Makerere University, Professor Vazira, yesterday I was online with him. I was telling him, actually I shared it with him, and he was like, we need to discuss these things more at the law school level. And even CLEs of law society should not only focus on human rights. Well, I'm not trying to say human rights are bad, but there is a business side which needs to put money in our pockets. And human rights activists, much as they're getting some donor funds somewhere, those funds do not really, they don't have that, what Milton Friedman called the trickle-down effect, somehow, sustainably. So I'm thinking that, one, how can we get there? One, law schools, we can start by talking out about these things. Invite some guys who can talk about them. Then at the law school level, maybe LDC can design some mentorship programs. People can come and discuss things at a small fee, certainly. And then for the seniors who are like Joel here and above, Joel has actually, maybe even Kenneth, I think law society should also do a lot of what we call, you have synergies with industry players, so that every time we're having a CLE like the one we have here for today, we have people who discuss not only one-sided discussions of how police is brutalizing politicians, that's a very important discussion, we should have it, but how we can spice up all these other things, and that is how we can build capacity. I was actually telling Joel, and I hope he puts it in his next presentation, I'm actually making a bridge, that lawyers, we are not sharing enough. Once Luis has got his car gig, I don't want to share it with anyone, especially when in areas like that are so emerging and we need collaborative effort. What that is doing is that it is killing our impression before the clientele. So once, as a lawyer, I get something and I'm selfish, I don't want to partner with people who know it better, and I do it badly. What that does is that it actually taints the reputation of each and every lawyer. Now, in these areas where you don't necessarily need a Ugandan lawyer to actually advise, per se, you will find that Kenyan lawyers will flood the space. And trust me, Kenyan and Mauritius lawyers have flooded this space. If you're looking for a lawyer to actually advise on even a Ugandan token, you will struggle. They are there. I'm not trying to say they're not there, but you will struggle. Why? Because as Ugandans, we are not go-getters. We are not forward. I was telling Kenneth that we are not forward movers, fast movers. So what I'm thinking is law society, through these discussions, how can we build capacity? Is not only should we discuss human rights and politicians being brutalized, because I know that's what law society has, that duty, but also have a duty to help the members build capacity and advise government well. Because now the virtual assets law is coming up. I am very sure if they tell me which lawyers are going to advise on it, I know like 5. Robert Chirunda, my former lecturer at Makerere, even Kenneth will be advising on it. So there are going to be a select few. And now the other lawyers will say, but those are the lawyers who think they know it all. That's not necessarily true. Is that they actually invested time in getting there. And I think the law society should help us, because trust me, the world is moving at a very astronomical level. I never thought that I would ever see a tokenization project, at least in Uganda. But I have seen 2. Actually, one is ongoing, and I'm writing a legal opinion on it. But I absolutely guarantee you that if you're going to bill a client on a tokenization project, it's not going to be less than 6,000 USD. It's going to be something even 10K USD. So these are areas where I think not only should the law schools at Makerere and UCU can start through what I call symposiums, inviting speakers. It all starts with, there's a writer who once said, and I'm concluding with this quote, the brain is not a vessel to be filled, but a light to be ignited. I think it was Platch, the philosopher. So let us embrace igniting our brains and not filling them as vessels.
That's the concluding shot. All right.
There's nothing wow about that.
Yeah. All right. Thank you so much for igniting the lights in there for all of us. We appreciate it. So we're just going to take a 5-minute break again just to switch up. We shall have another discussion in the next 5 minutes. Thank you so much, Louis. And I do hope that we can have more of these discussions. Perhaps we should start with law school, where we have been, and start from then and bring it up. Yeah? All right. Thank you so much. See you in 5. Okay. I think that was less than 5 minutes, but yeah, we're just trying to catch up with time. Following up on the past discussions on digital transformation, how we can make money from all of that, and looking at it from the finance sector. Now, we're going to have a discussion on bridging the gap between law and tech innovation. So this discussion will be handled by Joel Basoga. He has quite a heavy CV. I will start. He's the head of the Technology, Media, Telecommunication practice at HNG. He's a member of the International Bar Association Task Force on Artificial Intelligence. And for the last decade, his practice and teaching have focused on data privacy, competition, antitrust laws, corporate advisory, and several aspects of technology, law, and risk. He is a graduate of the University of Oxford. He has a Master's of Laws in Technology Law, specializing in data privacy and competition or antitrust law. As a Fulbright scholar, he has advised and represented several multinational and technology companies on data privacy compliance. And for the last 7 years, Joel's practice has focused on data privacy, competition, and corporate advisory and litigation services. He's known for his deep knowledge and versatility across a broad range of data privacy, banking, technology matters, and is a member of the ICT cluster of the ULS and ELS. He's a dynamic lawyer with global perspective, trained across 3 jurisdictions, the US, the UK, and Uganda. He holds degrees from the University of Michigan, USA, the University of Oxford, UK, and UCU. He has successfully represented major financial institutions in high-stake cases before specialized tribunals and appellate courts. He has served as a lecturer of private and public law subjects at the university. He's a recipient of numerous academic awards and has presented papers at leading conferences in Oxford, London, and Washington, DC, including the Privacy Scholars Conference held in the United States. So that's quite a lot, and we're happy that we're having this discussion with you. So what we're going to discuss, or what we just want to hear based off your presentation, are looking at the challenges and opportunities for lawyers engaging in tech innovation generally, and also lessons from legal tech entrepreneurship and strategies for adopting to new business models. I think this will just look at how you've seen it here in Uganda, and of course in all the other jurisdictions that you've been at, and what you've learned over time. And I think from also the different clients that you have been able to advise. So let's have it.
All right, thank you very much for that very kind introduction. If I may please have the slides up. Thank you. I would like to stand up for my presentation. So again, very, very good. Thank you for that wonderful introduction. And also thank you to KTA for organizing this event. It's a unique pleasure for me to be here. So I will use, give or take 15 to 18 minutes to run through my presentation to speak about what challenges and opportunities lay, for instance, for a modern lawyer as you think about technology and innovation. My profile has been read out. My presentation will focus on, one, just contextualizing how we should, understand innovation. What innovations have we seen, and what can we learn from those innovations, especially as lawyers? We'll also think about the traditional role that a lawyer plays, and should that change given the innovations that are around us? And then there'll be some key takeaways for what could you possibly do if you want to benefit more from the technology sector. So there've been a lot of innovations that have occurred. And I think even as we stand here today, we just had a wonderful presentation from Lewis. He spoke about blockchain and digital currencies, and that's all here. But also, especially here in Uganda and East Africa, we've had rapid advancements, especially for financial technology, I guess much more than blockchain. Right now, mobile money businesses move more money than banks do, although obviously and technically, the banks are holding that money in an escrow account, but we transact much more with our mobile devices than we do with the bank. And I think that should point towards something. But also we've seen that we're in the advent of the artificial intelligence, and there's a lot of innovations. Even if I was to ask anyone here, probably one of you has used an AI-based application. Either you've used ChatGPT, you've used Google Maps to get here, or you've used even the search engine now for Google incorporates a lot of high-level algorithms to help you determine your preferences. So we are actually in an increasing era where technology is part and parcel of us. And I think that means even as lawyers, we have to think about how this operates. But also, the rise of financial technologies, as I've mentioned, we have mobile money, we have several payment-based systems. Over the last 10 years, Bank of Uganda has licensed about 20 licensees to operate payment system licenses. That means you're not just paying people by cash. There's a whole enabled platform that allows you to do that. And I've spoken about AI applications. And so because of that, you can say that there is an increasing demand for a lawyer to understand how technology works, be it AI, and how blockchains operate, how does a payment system operate, when is it sealed, when it is closed, what are the risks. Now, some of these may not be new because the burdens and responsibility could fall on the same players to have a duty of care, but clearly the innovations we've seen should speak towards the fact that it's important and significant for us to think about technology, and therefore, what does it mean for us as lawyers? And I think one way to start this conversation is by looking at the fact that 3 months ago, the Solicitors Regulation Authority in the UK licensed an AI-based solicitor firm, which is meant to do clerical work, for instance, issue demand notices. These are roles that, for instance, lawyers have done. So we're seeing that just even the nature of our profession, especially a few tasks like those that are repetitive, especially in the sense of write a demand letter. I know that for most lawyers, when they start working at a law firm, either as an intern, the first thing that you're going to do is write a demand letter. You know, you can get an AI platform to be able to do that because it can learn from what you've worked on before and then can be able to write. And that's what the AI-based solicitor firm is able to do. But even then, I think the Solicitor Regulation Authority has mentioned specifically that AI-based law firm cannot analyze cases because of the risks that we have seen that have been widely publicized. When you ask a system to interpret cases or to give you an analysis of case law, you're going to see that it's not actually feasible. AI will come up with hallucinations. You know, there'll be a percentage of analysis which is correct. So the traditional work of the lawyer has not been overtaken because the actual work of reading cases, understanding how judges interpret things is still important. And the SRA makes that comment and says that the Garfield AI is not allowed to be able to interpret pronouncements of the law and tell people what to do. That function has primarily remained with the lawyer. But really, to drive the point home, we have a number of entities. These are both local and multinational that just drive the point home that technology is leading almost everything. So we have MTN, for instance, which is the largest telecommunications company that has come out on repetitive occasions to say they are rebranding as a technology-based company, and their main offerings are going to be data services, data centers, and also things such as the internet service provider. And that should signal you where the world is going. And therefore, I think that as a lawyer, you ought to be thinking about why is a large multinational company like MTN rebranding itself as a technology company. That should signal to you that everything is data-driven, everything is tech-based, and therefore you should begin to think. And other players who are local in the market, MTN, Momo, you also have Airtel Money. These are separate businesses that are making more profits than the parent companies. And it's just showing you that a technology-based solution is able to generate more money today because of how heavily digitized we are. And there's several other companies. I know that for a fact, most lawyers are using ChatGPT, to proofread their work, which again would increase efficiency, but also raises some concerns, especially on privacy and data protection. But also, most Ugandans, there's been a joke, most Ugandans like to watch Netflix, so you're able to sign up because Netflix hosts its content on a local server here, which you may not get when you are dealing with HBO, because HBO Max has not localized their data. And that means there's a lawyer who has advised Netflix, there's a lawyer who has advised MTN or MTN Ayoba. So you really have to understand how technology operates. And although there is a traditional joke in Uganda that in Uganda there are only 16 Netflix accounts, and those accounts are spread around the country because people share the passwords. I'm not so sure how much that is true, but companies, we also have local entities such as Barefoot Law, PLIDA, which is of the Uganda Law Society, that are doing several tech-based solutions. And I think that just shows you the era in which we are. So technology is the biggest driver for business. Most of the corporations have recognized that. Movies, for instance, are even no longer sold. You don't go and get a hard copy tape. That's not even there. You just want to stream the platform. So there's huge investment in data. Local, there are so many data centers that people are looking to invest, especially within East Africa. And so that means technology and technology-enabled platforms are, in a way, really taking foothold. And that means there's business for us as lawyers. That means you have to, I've advised some entities, for instance, a car manufacturer from Japan who, for instance, has asked us to, for instance, think about, they have an application, they want to be able to use it to know where at all material times their vehicles are, if someone purchases it, and that obviously has obligations because that data is transferred into certain places. And so that means there's going to be more work, which can be as simple as it's application-based, it's data-driven, but even traditional NGOs, for instance, most of them leverage data from local participants to share with their donors who are not based here locally. And so there's always a cross-border element to all of these issues. So that means that there's opportunities. There are over 20 licensed payment system providers or fintechs in Uganda. All of those need lawyers on retainer. So there's real business. And when we think of, we've spoken about some of the innovations in technology, then we have to think about what is the role of a lawyer. The traditional role of a lawyer is to review contracts, okay? Maybe draft them, but nowadays I don't think you draft contracts. So most of the clients that sometimes we serve, they come to you with an AI drafted contract and they are saying, just help me double check. So maybe our role has become to, reviewing. And I think as lawyers, we need to understand that, you can't claim to be guarding the idea of a perfect contract. Some of these systems will be able to generate for your clients who are not going to consult you. They'll generate these contracts. What they will obviously need is someone to tailor that contract to the standards of the relevant country. But lawyers also help with compliance. You want to buy a digital asset or you want to do a number of things. You have to comply with the law. For instance, you want to have a payment system. All these companies, chap, they have to be licensed by the central bank. And that, that's kind of like corporate and commercial law, but it does have a technical element because, you can't advise a tech innovator if you do not know what they think about. The way they think, they're thinking about venture capital, they want financing, and then they're coming to an old style lawyer who will sit on a brief for a month and say, I have a court case. It's going to be very difficult for innovators and entrepreneurs to relate with lawyers who are operating that way. So compliance, legal advice, dispute resolution always, and now especially with how technology creates cross-border interactions, disputes then will not have to be defined locally. There'll be references to different platforms, and legal risk management and response to legal notices, and the traditional work where we kind of go to court. So in terms of that, there are obviously opportunities, but there are challenges, and we'll start with the challenges. Now, some areas are not regulated. I actually think that's an opportunity because you're working in a vacuum. So as a lawyer, you have more creativity. But I also think that it has been empirically proved that when areas are regulated, then there's more business for lawyers. Because once, a non-lawyer knows there is a law, they will immediately think that they need a lawyer. So it can work both ways. So for instance, AI, we do not have clear positions of an express law, but we have overlapping obligations that come, for instance, from the Data Protection and Privacy Act, which provides data ownership, automated decision making. That area is already regulated. It's interesting though when sometimes people say there is no regulation on automated decision making, when we do have some provisions of the law that deal with that. Although I think the point there is that there has to be a specific law. For instance, we have the European Union AI Act, but I think the AI space is quite innovative. And I think that when a sector is innovating, you do not want to regulate. You want to let the innovation play out, understand the risks, and then when you understand the risks, you can regulate those risks and then place liability on different people. And that's been the approach when you think about innovation. Can you imagine close to 30 or 40 years ago, people were saying you should ban the internet, which almost sounds like a joke. So sometimes we hear people say you should ban AI, and that would be extremely unusual for you to say you're going to ban a platform that actually increases efficiency. So the lack of regulation could be a challenge, but I think that those conversations are ongoing in the telecommunications industry. We've, for instance, seen that there's an AI committee constituted in UCC. Different entities have AI standing committees, and there's beginning to be a conversation on how we can streamline this. But also the conservative nature of the legal profession, which is the idea that you must be closed out somewhere, the document must be printed out. We have some rules about how we operate that perhaps seem to slow down how we take on technology. And I think that that sometimes can be a disadvantage, because sometimes that comes from a misperception of how those rules operate. But also, I think some of the challenges are the ethical duties that we have. I think it's very easy for lawyers to run things through ChatGPT, but we forget that one of the most important duty of a lawyer is the duty of confidentiality. Just like a doctor, what allows clients to come to us is the fact that they are assured of confidence. So if someone tells you their details, then you run them through a system, which actually, according to a court order from a federal court in New York, they can subpoena ChatGPT and they can get all the information that you have fed into the system. So that shows that there are real issues, maybe not a challenge, but we have to understand how the duties of a lawyer operate in a virtual space. And I think that will take us towards the opportunities that we have to think about. So I think the opportunities are vast. Just from what I've said, data management is a critical part of business today. Almost all businesses rely on data. That means the Data Protection and Privacy Act and data practice of law is really, really important. So I think there are opportunities there. Cybersecurity has become more important than anything. The ability for someone to access your phone. For instance, if I told any of you that someone can access your phone remotely, you'd be worried. You'd want to delete a number of messages, a number of pictures, and because all our lives have been digitized, and that means there is liability. Once there's liability, that means there is a lawyer there, because a lawyer has to argue for liability, apportioning, and negligence. So I think there are opportunities there, especially even with fintechs. A number of them have obviously taken on lawyers. There are opportunities as you think about digital currencies, whether you're thinking about private digital currencies or you call them stable coins, or are there leading conversations on central bank digital currencies in other jurisdictions. And Bank of Uganda also released the paper in November last year where they were sharing what it would look like for them, although they said that's not going to happen very soon. But also there are opportunities in increased efficiency. On the International Bar Association, where I serve, we work with a number of lawyers who work in different, more advanced economies. And one of the partners for the law firm was saying, the AI can do much better work than the trainee associate that has just passed the bar exams. So if you they've trained an internal model, and if they ask that internal model to draft, let's say a securitization document, by learning from what the firm has done, that AI model they've trained internally does work that is 3 times faster than the associate, but also it's been able to do a draft that requires minimal input. So that in some way does increase efficiency. And I think that's how we should be thinking about some of these innovations. If you're drafting mortgages as a firm, you've been doing it for 50 years. Like, for instance, I work for one of the oldest law firms. There is no reason why you cannot learn off the precedents that you have done. And when you get new instructions, you feed the system the unique particulars. That can increase more efficiency. And I think there's so many other ways with how you draft pleadings, because lawyers are already doing that. They may be doing it in highly unethical circumstances, violating the duty of confidentiality and privacy by running this through open models like ChatGPT, but it's because we recognize that it can actually save you time, which can be both bad and good, because some lawyers just always want to have a timesheet and bill more. And so what happens then if you can get the work early? But I think the client wants work to be delivered early. And then there's also access to justice. Now we're dealing with an empowered community. They can just Google, and the Google AI Gemini is going to tell them a little bit of what they think are their rights under a contract. So by the time they come to you, they know much. So there's a broad idea of increased access to justice. And in the next slides, we'll see a couple of platforms that enable that. You know, for instance, we have Barefoot Law, which is, has been recognized by the European Union. They have an innovation that allows people to consult and get free legal advice on specific issues, and they've been doing it incredibly well. You know, there's Law Paddy, which is a little bit like Barefoot Law, but in Nigeria. And there's people are able to ask these platforms, if land has been sold, I've paid money but I haven't gotten the title, what can I do? There are lawyers who have trained some platforms to give you some preliminary advice. Approach the police or the enforcement agency. Now that sounds like very elementary, but for people who have not studied law, this is gold. That's the only reason why we even go to law school, to be able to understand how these systems operate. And we have Harvey AI, which most international firms have. They've created their own versions of Harvey to learn from the documents and work they have worked on to be able to increase efficiency. And I know that some Ugandan law firms are learning from these models. And then there's obviously another innovation called JibuDocs, which I learned about in Nairobi this year, that is able to help you generate certain information from cases that can help, especially as you do research, can help you be more specific. So the lessons learned, obviously, from tech innovations is, automation of repetitive tasks. Those can be automated. There's a strong need for collaboration. You cannot advise people in the tech space if you are only attending Uganda Law Society events, which is a little bit funny because most of the lawyers for the Uganda Law Society, they only want to get points. But the Financial Technology Service Providers Association is meeting. That's where you should be as lawyers. The ICT Association of Uganda is meeting. That's where you should be. The traders of Chikubo are meeting. That is where you should be. So there is a need for lawyers to expand their knowledge, especially in technology. You can't advise someone on tokenization. You don't even know what a token is. Okay, you don't know what a digital currency is. And we're not saying you're going to do the hardcore learning, some of the points that Louis has made. You can start off by just going on the Bloomberg website and reading up on this. But also, privacy and data protection is so intertwined with technology that I think it's unavoidable for any lawyer not to know anything about privacy. Almost all contracts I have reviewed this year will have a privacy clause, just as now intellectual property crept into all contracts. Intellectual property was not there 40 years ago. Now all contracts have an IP clause and now data protection. And sometimes lawyers craft these clauses and they do not understand the implications. You warrant that your client is going to comply with data protection, but at the moment of signing, they have not registered with the data protection office. They are collecting personal data. You yourself as a law firm have not registered. There are two flagrant violations of the lawyer themselves. So I think that privacy and data protection is fundamental to this, and intellectual property is critical because you're dealing with data. Some of it is protected, and again, we can debate what's protectable or not, AI innovations, but this is not an IP symposium, at least in a specific sense, and that was not the brief that I received. But there's a need for us to think about our role as a lawyer, and fundamentally key risks, especially lawyers use a lot of ChatGPT in Uganda. It's very stale. It's going to cite for you old laws. It's not even updated. For instance, just referring to the volumes of the law or the chapter of the law. And there are other risks like hallucinations, which we've spoken about. So in conclusion, there is a need for lawyers to become more tech literate, if you're trying to advise tech entrepreneurs, software developers, people who are moving in the fintech space, you have to understand how they think. And so I think that it's important for lawyers to think critically about that. There is importance for lawyers to participate in discussions about AI. Again, not as a threat. AI conversation should be prioritized. Digital commerce should be prioritized, and also fintech solutions, especially for this market where we have fintechs move more money in terms of daily transactions than banks do. Although, like I said, all this money is also held in an escrow account with a bank, so we can say the banks are the ones moving the money. But in terms of users, that is the case. And then more understanding of data protection and privacy. I think for me, that's one of the key areas. So tech literacy is important, and important for you to collaborate and expand your networks. And then also training stakeholders on AI use is important. Registering your clients and your law firms with a data protection office, because the moment you have a customer, if they're an individual, you're collecting their data. I think those are fundamental points and the starting points for this discussion. Thank you very much.
Thank you so much, Joel. I think that's been quite an interesting discussion, and it actually is very comprehensive. What I wanted to follow up, I don't even know if this is a question, but how we're mentioning how we have a limited use of AI, and most lawyers are still using ChatGPT. I also noticed that we do have local AI systems that are focused on laws, Ugandan laws, I think. And do you think those particular ones are helpful, or do you think that they're also limiting in some sense? I mean, we must also consider the fact that they are also AI systems. So do you think that using the local ones that are sort of created for Ugandan law would be best placed to be used by lawyers in Uganda?
Thank you very much for that question. I think that it's possible. Again, even when we say local, one has to understand if it's local. Some of these local AI platforms are building off open AI systems. So they may brand as local, but they are not local in the sense because they have not localized the data. But if local means that they have localized the data that is being used, then they could be a better option. I also think that it's also a fairly more complex issue, especially because I know a number of AI-based applications, but most of them they're not closed systems. So for me, my concern would be, are you using a closed system within an organization that helps you fulfill your duties of confidentiality, while there can be this overarching objective for us to buy Uganda and build Uganda. Yeah. Unfortunately, not many of the local innovations have the capacity that these large based data-driven platforms have. And so I think actually we might benefit from collaborating, and then that's where organizations such as the Uganda Law Society or us can say, how do we think about using these systems and then localizing the data, tagging it to ULI. So there is an opportunity in localization of these platforms, but I have not seen how most of them differ from the much global platforms.
Okay. All right. Thank you so much. I think one of your concluding remarks was just on how lawyers should expand their areas of practice and leave just traditional practice, and also just look at the new emerging areas, and that's very nice. I think I've also noticed the Data Protection Office also does give us trainings, I think, on a monthly basis, and so this is something that lawyers can also take part in and just keep updated. That will be the close of this discussion. I do not see any questions on the platform. Thank you so much, Joel. It was it has been, yes, top-notch discussion, very easy to understand. Yeah, thank you. Thank you so much. Thank you so much. All right. All right. We'll have the next discussion in the next minute, and it will quite take a shorter while. Yeah. And it will be hosted by someone else. All right. See you in a minute.
Hi, everyone. Thank you so much for joining us. This is our last session done by Council. This is our last session. It's going to be done by Council Terry Kahuma. I'll just go ahead and give a brief bio. I know Terry personally. We went to school together. And we're friends. So Terry has been very instrumental in just a number of law areas. He's passionate about energy, law practice, technology and the law, land, and aerospace law. I don't think we can say that we have a lot of Ugandan lawyers that are focused on aerospace law, so that's a big deal. He is also very interested in philanthropy. He has created a social media page called Simply Legal that has amassed in total on all social media platforms a following of 50,000 plus followers, which is a big deal. On this platform, he breaks legal opinions and ideas down for the common person, which is a big deal because accessibility. He has won awards such as the Young Legal Innovator of the Year Award at the African Legal Tech and Innovation Awards of 2022. And recently, a Digital Excellence Award was given to him in August of 2025 by the Uganda Law Society. I will now hand over to Terry, who will take us through his presentation, which will be on how lawyers can use tech to creatively enhance legal practice. Over to you, Terry.
Okay, thank you so much, Vanessa. I greet you all. It's such a pleasure to be presenting in front of Ken. Ken was my former lecturer at UCU. He taught me IP 1 and 2. So I've been growing in this with Ken. We've been interacting since I got out of law school and LDC. Yeah. So I'll be brief because the moderator asked me to be as brief as possible. I made my slide quite brief and I didn't want to dwell so much. So I think this will be a bit more interactive to be question and then. So I'll just give a background of how I started getting into the love for tech law. Still, I'll always associate this love with Ken because I always loved technology from the beginning. So when I was learning IP 1 and 2, I always wanted to know how does technology work and how are we regulated? how do lawyers come in? Because I know that lawyers come in into every aspect of life. Very soon, even the air that we breathe, there are going to be regulations. Because there's water, there's what, but air at a certain point. I think even hospitals, when they're giving someone an oxygen tank, there should be some sort of policies and regulations. So I went to LDC. That was 2019. So just before the COVID-19 pandemic came, I always had this idea that, why don't I start a social media page where people will learn these laws? Okay, I thought about it and I said, but I'm going for LDC. Am I going to have time for this? I said, let me leave it. And I'm also not a YouTuber. By the time it was only YouTube that was there. TikTok had not yet blown up. So the pandemic came and I had a lot of time. I said, okay, let me try this. So I started literally doing videos on selfie mode. I'll do videos, okay, guys, I'm Terry Kahuma. Do you know your rights about this? Do you know your rights about this? With poor quality editing, there was nothing professional about it. But I said, okay, let me just go with the knowledge I have, my brain, my wits, and let me just practice what I can do. So this was a very virgin area of the law. Like no one at all had ever, I think I'd only heard of barefoot law, but no one had ever attempted this kind of thing, at least not in an organized group. So that was 2020. I kept refining my skills. I had no idea of videography, editing, nothing. But I had to learn how to do all these things because by the time COVID, there was no interaction between people. So there I was at my place, lockdown. I had a lot of time. I would just edit simple videos. So I learned a lot of things along the way. I learned how to better my speech, confidence, self-esteem, and also how to properly research my skills on how to be a better lawyer. So fast forward into 2021, I found myself getting better. I said, okay, I've now moved from one subscriber to another subscriber. So that was now YouTube. I had not yet considered TikTok by that time, but I was like, okay, let me focus on what is a major platform that's there. So YouTube came from one subscriber to the other. So my biggest breakthrough at that point was reaching 100 subscribers. By that time, reaching 100 subscribers was a very big deal because, YouTube even sends you these kinds of emails. Oh, Terry, you've reached 100 subscribers. This is good. You're building your community. So I was like, okay, this is now working. So as I kept moving, I noticed a number of challenges. Number one, I knew that I had to get better equipment because I couldn't stay. I think by the time I had no iPhone, I think I just had a Samsung A20. Okay, I'm like, okay, let me just use this. But I knew that for me to keep getting better at my craft and skill, then I had to invest in better equipment. So I had to save up money here and there. That means I had to engage more with clientele who would find me on my platform. So the more work I do for them, then the more I get money to be able to buy this equipment. So I bought myself an iMac. I bought myself, I think, by the time it was an iPhone. I think I had a red one. So I think that was an X. I think it was an X. So, but I'm very surprised that you remember that. So, by that time, the only person who, aside from me doing the selfie videos, only other person who would help me to do the videos was my girlfriend. So we would get like a perfect spot, like, okay, this is a perfect spot for lighting. Okay, now here there's a bit of shade. Okay, here the birds are making noise. So it has been a journey for me. I didn't have all this fancy equipment, and so anyway, fast way forward, I hit 1,000 subscribers. That was 2021. And I could not believe it. I couldn't believe that people would be interested in legal knowledge. So okay, I said, let me keep pushing with this. But as I kept growing, I kept noticing challenges. One of them was I actually lost friends along the way. Not that, it wasn't that the friends were lost out of bad will, but I noticed as an innovator, or as someone who is breaking ground into a new area, you're definitely going to lose friends, because most people do not understand what you're doing, why you're doing it, for what purpose. And at a certain point, you will become even a laughing stock. Majority of the innovators all over the world, Thomas Edison, Jefferson, all of them have been laughing stocks, where they said they were going to make maybe a light bulb or something. So all of them became laughing stocks. So I would be at LDC. I think by that time, the lockdown had now been lifted. So at that time, the lockdown had been, the bans had been lifted. So now we went back to the center. So I'd be there. I'm maybe going to shoot content, and then I can hear, oh, by the way, your former friend was saying this about you. They were saying that maybe your channel sucks or something like that. And I'd be like, really? Of all people, him? And you find that you are with this gentleman right away, maybe from primary or high school or something. But it helped me to develop a very resilient mindset. I said, okay, I know what I want. Let me keep pushing this. There's a bigger objective. So as the channel kept growing more and more, I realized that I needed to expand to different platforms. I expanded to TikTok, I expanded to Instagram, Reels. And then I had to categorize what I do on the channel. I'm not just going to do blanket videos. So I came up with what's called Legal News Daily, and then also Legal Tips. So Legal News Daily it's now like there are almost 3 channels in one, because they're all heavy power players in themselves. Legal News Daily is where I get current events that are happening. One of the most common being, let's say, Bobi Wine has been arrested, or maybe this politician has been arrested, or maybe Donald Trump has threatened maybe to send missiles maybe to Russia. Then I go and read an article. I get the key points in it. I do heavy research on it. Then I ended up coming up with Legal News Daily. So I do a daily legal news segment where I demystify and break down complex legal concepts for people to understand. Then there was Legal Tips, where I can do it in a skit form, or I can do in a format where these are daily or day-to-day challenges that people face. If you parked your car maybe at National ICT Hub and you didn't leave it locked, and maybe someone comes and steals your car or steals, and then you see a notice there saying at owner's risk. Most people don't know what does at owner's risk mean, but there are many legal aspects there, but it's only us lawyers who will know. But a common man will just come and park his car, and he just says, okay, maybe this is just a company policy. But he doesn't know that the company is telling him that whatever happens to your vehicle here, the company is not liable. So I noticed that as the channel kept growing more and the brand kept growing more people had more questions and feedback to ask of me. Then I would respond to them with another video, another sequence. So that's how I differentiated the two, Legal News Daily and Legal Tips. Yeah, so that's basically a background. I'm about to finish the background, then you can ask. So right now on TikTok, I'm on 36,000 followers. I noticed people like the Legal News Daily segments more than the Legal Tips. For some reason, people like knowing current events more. They get more views than the Legal Tips. You can do a Legal Tips in 2020, and right now it will reach maybe 5,000 views. Yet a Legal News Daily segment on Bobi Wine has been arrested in Busia. And what are the legal implications of it? By the time I release it at around 3 p.m., by 9 p.m. it can have 50,000 views. So people love to know these current events. What can happen? Who is responsible? Can government be sued? Can NOP be sued? Things like that. So yeah, that's what I can say.
Thank you so much, Terry. A round of applause. It was very insightful and also so inspiring, just from the aspect of a young lawyer. Yeah, it's such a big deal to see how far you've come and what you've gone through, starting from just a few followers, 100, 1,000. But I think the first thing that the people want to know is, are you still with the girlfriend that was making the content with you?
Yes, I am.
Okay, love that very much. Okay, so my first question to you, Terry, would be, what key lessons can young lawyers draw from your journey in balancing traditional legal work with building tech-based platforms like Simply Legal?
That's a good question because I wasn't only doing Simply Legal when I left the center. I also went to do practice at the Uganda Electricity Transmission Company, that is UETCL. So while I was there, I entered in as a trainee legal officer. So a trainee, you're just above an intern, but then you're below an officer. So that came from the traditional British system that we had, where British Council and the colonial government used to have the trainee system. Students would come out of these schools, Budo, Ntari. By that time, the schools that were there, you go to Makerere and then you come out as a trainee. So they were being funded by the British Council. So they would put you inside most of these institutions like National Water, UEB by that time. Now, when UEB was broken off, I'm going to give a background. When UEB was broken by the Electricity Act, we now had transmission, distribution, generation, and then ERA. But all those companies retained the trainee program. So the trainee program was for 3 years. So as I was doing that trainee legal officer job at transmission, I would balance it out with this, my other hustle with Simply Legal. But what I would say is that most lawyers think that it's hard to balance a traditional job as a lawyer, either at a firm or at an entity, while you're trying to do your side hustle. But I actually found it easy. If you just plan your time very well, you know that I can wake up at 6 a.m. or 5. If you're going to do a legal news daily segment, you're going to go and research, go on Opera News, go on BBC, find out if Trump is threatening maybe to go nuclear, let's say with Russia, or maybe an international arms deal is going on. What are the legal implications of it? You do your reading for like 2 hours. Then you go to your normal day job, whether you're at a farm or you're at an entity. Do your normal 8 to 5. Once you're done, you already know that you did your research in the morning. Then from 5 to 8, you can do your shoot. So with that, you can be able to balance your work life and your side hustle.
Yeah, I can absolutely relate to that as someone who also runs a business while also doing my work. So in your experience, what would you say the biggest challenges are in young lawyers? Because you've told us about how difficult it was for you while you were setting out. You were using a Samsung, which, not to say that Samsungs are bad. They're not. But you were struggling with like equipment, the video quality was bad and all that. So what would you say the biggest challenges are that young lawyers face in embracing technology and just being able to use it in order to branch out, but also while they're doing their work?
I think the biggest thing is self-esteem. Why am I saying this? To be able to know that I've started a platform and I'm working in someone's entity, either it's government or a private entity, and I need the money, I need the experience from government or from someone's firm, but at the same time I need to break out on my own, because ultimately I believe every lawyer needs to be on his own at a certain point. Either you're doing your own private practice or you have your own firm, because you'll never be able to sprout out as a land person like we are. So technology. If you have your iPhone or your Samsung and you want to begin Simply Legal or any platform where you teach about the law, just start without equipment. The most you can do maybe is to invest maybe in like a mic, a wireless mic of like 30,000. So you need to be able to invest intellectually, read, but also don't be afraid to sprout out. Don't be afraid to say, okay, right now it's evening time, I think I should give time to my platform. Something else I didn't mention while I was doing Simply Legal is in 2022, I had another epiphany. I had an idea and I said, okay, after I begin Simply Legal, what else can I do in the legal tech space? So I decided to come up with an app called Farmeron, which connects people and lawyers together. So while I was doing that, I said, okay, I already have my job at Transmission. I have Simply Legal. I have my personal life. How am I now going to add on this app? Already running an app is so crazy. So, okay, I said, let me just wing it because I'm young. By that time, I was 25, I think. I mean, there's really no excuse. Maybe my big excuse would be finances, but let me just do what I can in my capacity. So I went. I said, okay, I sat in my room and I was like, okay, I don't have the big finances to begin an app. But I thought to myself and said, what do I have? What I have is a brain. What I have is the will to do it. And I know that I want to make an impact in life. I got this inspiration from one of our former headmasters who used to tell us that you need to aspire to inspire before you expire. So we all know that as human beings, our lives are like candles. We come into the world, we burn very fast, but at a certain point we can go at any time. So I said, okay, if I'm going to manage all these three aspects of my life, including an app, let me just do this. So I thought about getting an investor. I came up with a whole sales pitch. I said, okay, I'm going to. I went and told my parents about it. I went and told my dad because my dad is a technology person. He's an engineer. So I went and told him. I knew he would relate easily with this. My mom would want me to be more in the sure space. You have your job at Transmission. Why don't you do this? What? So I went and asked my dad. I was like, I want to begin an app. Okay, but now money is the issue. How do we get this? Let's go and get an investor. So we came up with a list of people who we thought would invest. Of course, I'll keep the names private. So, I went, I approached a couple of investors, like 3. We zeroed down on one because the other 2, it seemed not to be their field, which I was aiming for. They seem to have been more in the traditional space, maybe goods, production, and services. So I went, I approached the investor who seemed to be more interested in it, came up with a whole budget. You know, when you're a young man, you're so ambitious, you believe that you're going to come up with a very big budget. He looked at it and was like, young man, this budget is too big. I'm going to start you off with half of what you want. And even that half, he gave me half of it. He's like, first start with this. I'm very sure that because in his business, he runs apps. So he also has an app which runs his business. He's like, I'm sure this is going to start you off. So start with this. The more progress you make, then you come back, I'll give the other half. So I was like, okay, I didn't expect this, but let me start. I went, I started, I had a friend of mine who was doing software at Makerere. I approached him. He did the app on the budget that we had, and we started. So the app had more challenges than Simply Legal. Simply Legal is a bit easier, just captivating people's attention. Once you know how to captivate a human being's attention, it's easy. But an app, to get people to sign onto an app, especially where they are lawyers, you know, the nature of our work is so delicate. I found Farmeron so difficult compared to Simply Legal. Simply Legal was hard initially, but I got the hang of it. But the app, because everyone will ask, are your lawyers vetted? Are you working with Uganda Law Society? Are you... the questions are so many. And most people are used to knowing that I have my lawyer here. We have a family lawyer. Or our firm has been H&G for the last 50 years. But it's like the app was like its own virtual law firm. So actually right now we kind of put the app on remission, on hibernation, because we're trying to upgrade it to fit into the standard where it is even more simplified for people. But this journey of legal technology has been a very inspiring journey. I've loved it. It's something that I'll never regret doing in my life because it has exposed me to so many things, so many people. The awards I've gotten, I didn't even expect to get them in this journey. From a guy who was using a Samsung A20s with a selfie video. I did not expect to get, you know, telling you, oh, you have an award here. Oh, I said, okay, I didn't know. So you go and you cannot believe it because you still see yourself as a guy who started, but not as who you are now. So I think that's to the young lawyers. It's to You know, there's a lot of power in self-belief. I'll give you, before I finish this point, I'll give you a brief. One of my biggest inspirations in the world is President Abraham Lincoln. Lincoln went through so much in his life. By the time he became a president, he was about 65. This is a man who started a family very young. By that time, I think he lost his father early. His mother was really poor. I think he was the first of 3 children. He literally had to teach himself how to read and write. He taught himself how to be a lawyer. Ran for Congress, lost, I think, twice. Ran for Senate, lost twice. A storm came, blew away his house, killed his wife and children. He went through so much. I think he ran for president once or twice and lost. By the time he became president, he was really old. Later on, he was assassinated while he was in office. But to show you how much self-belief a small boy, I think he was from Indiana or something, how a small Abraham Lincoln became one of the biggest figures in the world, it shows me that the biggest asset we have and that God put in all of us is self-belief. The moment you can believe in yourself, trust me, you can achieve so many things. So as for the young lawyers listening, I'm your fellow young lawyer, but I think we can achieve what we put our minds to.
Thank you so much, Terry. Yes, yes, a question.
Thank you very much, Terry. I am very happy to meet you because I have watched your channel. But also I am very inspired by people who follow their aspirations. And also even you've mentioned Abraham Lincoln. My favorite book is written about him by Doris Kearns Goodwin, Teams of Rivals. Why I asked to speak was to just say that I'm deeply inspired by what you've been able to do. It's so important for people to follow their own aspirations and don't let anyone tell you that you can't do anything. Okay, they may tell you they will always be there. I think the world is already a very difficult place to be. You know, those people will always be there. But one of the most liberating things is following what your spirit has been prompted to do. And I think for you to be able to do that in our very conservative profession, where lawyers are not even supposed to talk about the work that they do, I think that is extremely inspiring. I feel my heart feels very full to be able to share the room with you. That's what I wanted to say. Thank you.
Thank you so much, Joel.
Thank you so much, Mr. Joel Basoga. That was very touching, even for me. I think I'm going to use this opportunity to speak about my business, since we've been
sure.
We've been told that follow your dreams, listen to what's in your spirit. And that's very important just for young lawyers and everyone out there, really. What God has put in your spirit is a seed that you should allow to grow and sprout. So my business is called Trinkets of Brass. I sell brass jewelry.
By the way, I think I've supported you before.
You have. Afrocentric brass jewelry. Yeah, in addition to my work as a lawyer. So Terry, this has been such an insightful, lovely chat with you. Any parting shots?
To the young lawyers or to everyone?
To the young lawyers especially. Us as young lawyers, let's focus on the young lawyers and yeah.
Okay, to young lawyers, I believe the youth is always the future of every generation. Don't be dismayed by conservative practices. Of course, the conservative part has to be there because there has to be law and order, definitely, because that is how previous generations have survived. But trust me, if you know that a certain regulation tells you do not advertise, because that's one of the biggest questions I used to get. I would meet my former lecturers at court and I'd be like, aren't you advertising, Terry? Aren't you going to get problems with Law Society? Actually, majority of them would ask me that. I'd be like, no, I'm not advertising. Because advertising would be me saying, I'm the best lawyer. Come and find me here. I'm Terry Kahuma. But I would just be like, no, this is legal education. So there are always loopholes around everything. I'll give you an example. Even something very far away from this. Most people do not know that majority have gone through what are called near-death experiences. I think you've heard of those, what are called NDEs. So usually in my free time when I'm away from being a lawyer, I listen to a lot of NDEs. So a lot of people will say, I was diagnosed maybe with, let's say, colon cancer. Or I hope I'm not touching any sensitive topics here. Okay, someone will be diagnosed with Parkinson's or something. While they're on their deathbed, they get what's called a near-death experience, or what's called a premonition. While the doctors told them that what you're being diagnosed with, you have no chance of survival. But while they are on life support, they go into a near-death experience. Either they meet Jesus, and then he's able to jumpstart them back to life. When they come back into, like they get back into life, the doctors check them and they do not have any ailment. So those are some of the loopholes that exist either in the natural or in the supernatural. So to kind of relate back to this, as a young lawyer, if the law says do not advertise, if the Advocates Act says don't advertise, you can say, okay, if I'm not advertising, can't I teach people how to recover their money? If I lend someone 100,000, how do I get it back? Do oral agreements hold, or do written agreements? Are they the ones that the courts look at? So to the young lawyers, a parting shot is, don't be afraid to chase your dreams. The world is a blank canvas, and it's painted white everywhere. We might see regulations everywhere. A chair is supposed to be here. A desk is supposed to be here. But you should ask yourself, if I turn this chair anti-clockwise, what happens? Or can't I rearrange this chair to be maybe metal instead of wood? So it's just about being creative. Yeah.
Thank you so much, Cherry. You've had young lawyers out there. The world is your oyster. You can do whatever it is you set your mind to. I would like to ambush Mr. Kenneth Mohanji to come and give us our closing remarks. Oh, we have some questions? Oh, thank you for that applause.
No, guys, please, one more round of applause, and to the online audience. This man has inspired me. And really, about 9 years ago, when we started this symposium, before it was called the colloquium, then it became the symposium. Like Terry there, we were in uncharted territory. We did not have law firms that were conducting CLEs. That was the preserve of Uganda Law Society. But then we started to see that there were many advocates in Uganda Law Society. And the challenge with having too many people somewhere is that it is difficult for all of those people's interests to be recognized or to be furthered or grown. And one of those that really I felt needed to be emphasized was lawyers that were interested in these areas of law, lawyers that were interested in what we are calling emerging, but they are not emerging. Like Louis mentioned here, you may think that stablecoin and cryptocurrencies are emerging, but they've been here for decades. You may think that artificial intelligence is emerging, but it has been here since the 80s or 90s. You may think that lawyers that dispense legal advice using these digital tools are emerging, but no, these have also been there from the dawn of the internet. And so I can go on and on about this, and I feel that as Uganda Law Society, we should be inclusive enough to be able to cover all of these areas of law. And thankfully, this ULS has been doing this with us for the last 9 years. And so that means within Uganda Law Society itself, we have a critical mass of lawyers that are interested in furthering. And I really like what Terry mentioned about how the stories we tell ourselves about what we can do and what we cannot do. I feel there's a lot you hear in this country about people telling you what you can't do, and like he mentioned, regulation here stopping from doing that, this from doing that. Even in your own home, because Uganda Law Society is your own home, people are telling you you can't be able to do this. Other people, will tell you you're just going to waste your time. But at the end of the day, you go to sleep in your bed alone, okay, or with someone, but you wake up in the morning alone. We come into this world and you take that breath alone. You may have other people, community, parents, guardians that help you and guide you on that journey of life. But overall, that journey that you take is yours and yours alone, because when you're passing away, and that is the journey for all of us. It's not a sensitive topic, Terry. All of us will pass away. When you do that, at that particular point, how will you have lived your life? So I want to close by reminding you that how you live your days is how you live your life. And as an advocate, how you practice law every day is how you will practice your law every career. So if you're listening to all of that outside noise telling you can't do something, you can't expand, you cannot be able to make money from the practice of law, you can't be able to branch out and do all of these things, what about Terry Kahuma? What about Mabel Chisaka? What about Louis Chizito? What about Joel Vasoga? What about Olga? All of these people have come to show you who is listening, that it is possible for you to grow your practice, it is possible for you to thrive in a Uganda Law Society or in a country that is telling you all of these stories about yourself. So what is the story you're telling yourself? So I'd like to thank all of the panelists here, all of the presenters here, the KTA team, Zaina, Tracy, Lauren, Catherine, Celine, the head of policy there. We have other people in the room like Raymond from Dear Young Lawyers series. You have Joseph over there. Of course, Nalubega, Yiga, Vanessa, Claire, who already told us about her trinkets, Patience behind that side. And then, of course, Uganda Law Society. Drake Lubega and your team, thank you very much for the work you've done today. Ruth, Doreen, the CEO of Uganda Law Society, and the Council of Uganda Law Society as well. To our VP and the entire Council, thank you for partnering with us with this. And we look forward to tomorrow, where we are now going to be having even better, or not better, but more well-rounded discussions around topics that perhaps we can be able to interest you, because now, today our focus was on advocates. Tomorrow we shall be talking to our public. And so I encourage everyone who is here as well. Terry, Joe, please do come tomorrow. We are going to be at MCI Hub in Zambia. Do come so that you can then be able to interact with our audience, with our public, and in ways that will continue to help us further our profession. For me, who has walked this journey, and of course also seeing that everything today you're seeing has been organized by Celine and Iga here, who took lead, it is an honor, it is a privilege for me to be part of this as someone who is now sitting and listening and enjoying the presentations as compared to how we were in the past before. Ali, they say the Gen Zs do like what? Like. So thank you very much for your time. For the online audience, thank you very much for taking the time. We shall see you tomorrow. God bless you.